Thank you. Please be seated. The first case on our docket this morning is styled LeHouillier, I believe, versus Gallegos. We've got this set for 1 hour, so that'll be a half hour aside. Counsel for the petitioners, you may proceed when you're ready.
Thank you, Your Honor. If it please the court, Malcolm Mead of Hall and Evans, bar number 11684, for petitioners and cross-respondents, Patrick LeHouillier and his law firm, LeHouillier and Associates, PC. And with me at counsel table is John Bomer, also of Hall and Evans, handled the case in the trial court. Every tort case requires proof of 4 elements: duty, breach, causation, and damages. An action for legal malpractice requires proof of the same 4 elements: duty, breach, causation, and damages. But an action for legal malpractice based on the loss of an underlying case requires proof of these 4 elements 2 times over: duty, breach, causation, and damages as to the underlying tortfeasor, and duty, breach, causation, and damages as to the attorney. If the attorney's negligence deprives his client of the chance to obtain a judgment against a tortfeasor who has no assets and cannot pay that judgment, the attorney's negligence has caused his client no damages. Therefore, the client in action for legal malpractice based on the loss of an underlying case must prove that the tortfeasor had sufficient assets to pay the judgment. If he does not do this, he has not proved that the attorney's negligence caused him any damages. This is the rule followed by the majority of jurisdictions across the United States to consider the issue. But the majority of judges on the panel below chose to follow the minority rule, under which the attorney must carry the burden of proving the uncollectibility of the judgment as an affirmative defense, effectively placing on the attorney the burden of disproving the elements of causation and damages. Many reasons are offered in support of the minority rule, but none of them withstand analysis. The first reason offered is that the plaintiff in a normal tort case does not have to prove the collectibility of the judgment he's about to achieve as an element of his case in chief. That's true, but it's also irrelevant. An action against an attorney for legal malpractice based on the loss of an underlying case is not a normal tort case. An action against an attorney based on the loss of an underlying case requires proof of a case within a case or trial within a trial. The damages caused by the attorney are not the damages caused by the underlying tortfeasor. The damages caused by the attorney are measured by what the client would have collected from the tortfeasor on the judgment he would have obtained. Courts also say that collectibility would not be an issue but for the attorney's negligence. Well, nothing in a tort case would be an issue but for the defendant's negligence. That argument applies to every case. Excuse me a second. Courts also talk about the delay which will occur between the original tort and when the attorney would have been sued for legal malpractice. If you have 2 statutes of limitation in line, so that the action for legal malpractice will come to the court long after the original tort occurred, and in the span of time, memories may fade, documents could be lost, so proof of collectibility could be difficult. And so in the interest of fairness, let's place a burden of proving uncollectibility on the attorney, because somehow it's easier for the attorney to prove uncollectibility than for the client to prove collectibility. Well, that's not true. If the attorney investigated collectibility in the underlying case, that information will be in the attorney's files where it's equally accessible to the client in the action for legal malpractice. If the attorney did not investigate collectibility in the underlying case, then both the attorney and the client are in the same boat. They have the same burden to obtain the financial information from the tortfeasor. Not that that's a difficult position, because usually I just take a subpoena duces tecum to the third party, have them produce your insurance policy. But the burden is the same for both client and attorney, so there's no reason for saying it's easier for the attorney to put the burden on the attorney to prove uncollectibility. Some courts take that fairness argument one step further and say, well, between the innocent client and the tortfeasor attorney, the wrongdoer should bear the risk of unpersuasion on collectibility. But you could say that in any tort case. Between the innocent victim of the car crash and the defendant driver, let's put the burden on the driver to disprove causation and damages. But you don't, that's not how things work in a normal tort case.
Mr. Mead, good morning. Can I throw another kind of fairness question in there? Would evidence of, in this case, the doctor having had insurance, would there be a motion in limine to keep out the fact that there's insurance play a part? Because all of a sudden they're going to hear that there's a $1 million insurance policy. Would that come into play at all?
I believe the evidence would be admitted, would come into play on the issue of collectability. I believe your question addresses the Rule 11 concern that normally in a tort case, evidence of insurance should not come in. But Rule 11 just says it doesn't come in on the issue of liability. It's free to come in on other issues. In action for bad faith breach of insurance contract, people talk about insurance all the way through the case, which is part of the case. In an action for legal malpractice based on a loss in underlying case, proof of collectability would have to be addressed and most easily addressed through an insurance policy. You could have an instruction from the court saying, this, you've heard about the policy just for one purpose, the purpose of collectability, but it has to come in. Right. Rule 11 would not bar it.
Well, while we stopped you, if I have a different fairness question. You all, your client alleged as an affirmative defense below the issue of collectability. I guess it's a little troubling to me whether the plaintiff kind of gets surprised by that. When you assert it as affirmative defense, I could understand if the plaintiff, they expect you to come forward with evidence and they sit and wait. But in this case, then at the end of the day, we get a directed verdict and a JNOV motion saying, no, it was the plaintiff's burden. So maybe can you discuss that? Why shouldn't we, at least in this case, mind your client having raised it as an affirmative defense? Shouldn't they be a stop from now saying it's not an affirmative defense?
Certainly address that. And with all due respect, Your Honor, you have to read the caption under which that defense was listed. It does not say affirmative defenses. It says defenses and affirmative defenses. Both Rule 8 and Rule 12 require the defendant in a lawsuit to assert all defenses in the response of pleading. So under defenses and affirmative defenses, we listed every defense that we're going to make in the case, including collectability. Now you address the issue of surprise. There it is in our answer. We said collectability is an issue in this case. We gave them notice from the very beginning of this case, collectability is an issue, and it was not addressed.
So I think sort of related to that, I mean, it does seem as if they were assuming it was an affirmative defense. How has collectability been dealt with in legal malpractice actions in Colorado up to now?
If I can address that in 2 steps, Your Honor. The first, to say that they assumed it was an affirmative defense. If you read the transcript of how they responded to the motion for directed verdict, they didn't say that at all. They said, oh, we have to prove this, we've got to prove this. Oh, well, we did. All this evidence came in, all this testimony, the letter to Dr. Hughes. They said, oh, yeah, it might be our burden, but here's all this evidence. So they just took it as saying, we addressed it, here's the evidence. They didn't stand up and say, oh, we thought it was theirs because they said affirmative defense. So that's not an issue in this case, factually. And I lost the second part of your question already.
How has the issue of collectability been handled?
That goes back to the case of Lawson, and excuse me again, sorry.
So let's not talk about Lawson, actually. I don't think Lawson addresses this. I'm asking it as a matter of practice in the past 20 years. How has the issue of collectability been handled in legal malpractice claims? I assume it's come up before this case.
In Colorado, you mean?
Yeah.
Am I allowed to talk about an unpublished decision? As far as I know,
doesn't bother
it's only
me.
come up once, and that was in an unpublished decision. And in that unpublished decision, they said it's the plaintiff's burden to prove collectability. I'm not aware of any other case which specifically addresses it, although there are a number of cases which talk about it's the plaintiff's burden to prove recovery, it's the plaintiff's burden to obtain a judgment. They don't get to the issue of collectability itself. It just wasn't an issue in the case. So the final resolution is left unresolved, the actual issue.
Okay, and again, I'm sorry do you have any information about how, not in appellate decisions, as a matter of practice, how have these cases been litigated? What are people doing in the trial courts in terms of the issue of collectability?
I would have to say I don't know, Your Honor.
Okay.
So that actually brings to mind a question that I have, and I see the merit of your argument, but I'm troubled by where it leads us because it has this sort of gotcha quality here. there's already been a determination of negligence by the doctor, by the attorney, and there's a statutory obligation to have, as I understand it, at least $1 million worth of insurance. Sure, we don't know exactly what kind of insurance policy, but, and yet, the outcome that you would have us embrace is one that just leaves this plaintiff without any judgment at all. So help me understand why that doesn't seem unfair to this particular plaintiff in this case.
Well, to address that particular fairness argument, I'd say, how difficult would it have been for them to approve collectability? You say there's a statute that requires $1 million insurance. Ask the court to take judicial notice of the statute. Ask the court to instruct the jury regarding the statute. Didn't do either step here. They didn't ask the court to take judicial notice, didn't ask the court to instruct the jury about the statute. You could have called Dr. Hughes to testify. Dr. Hughes, you were the doctor, yes. Did you have insurance? Yes, no. How much insurance? Was it claims made or was it occurrence? Would have been very simple to address, so I don't really see the fairness problem. If a plaintiff doesn't prove causation, that's their problem, even though it may seem unfair in the end. Could have been done very easily.
Well, let's assume that we decide that Lawson didn't answer the question. And so this is a question of first impression. So in other words, it wasn't decided at the time of trial.
You know what?
It was not decided at the time of trial in terms of who has the burden. In that case, you're saying that if we go with your position and we find that this should be, the burden should be, as I understand your brief anyway, I think you're saying that if we end up deciding that the burden should have been on the doctor, that we should remand for a new trial, correct?
Burden should have been on the doctor. The doctor's in the medical
On
malpractice.
excuse me, on the attorney.
On the attorney. Okay, our position is the burden should be on the plaintiff. But if you, excuse me. So if you rule that the burden should be on the attorney, then the next step procedurally, that's your question, what happens next?
Right.
I'm not sure that this addresses your actual question, but let me try this. But cool, okay. You could not just affirm the judgment, which was entered for the plaintiff, on the basis that we did not present evidence of uncollectability, because the trial court ruled it was plaintiff's burden, and plaintiff, when they responded to the motion for directed verdict, said it's our burden, and we were relying on the Lawson case, which says it's the plaintiff's burden, as well as 3 treatises on the law which say, yes, Lawson says it's the plaintiff's burden. So that was the established legal reasoning. Perhaps that answers your question. The legal reasoning was that the plaintiff's burden of proof at that time, based on Lawson, although I agree there's some room for dispute about Lawson. So you can't just say affirm the judgment because we did not present evidence of uncollectability, because we were relying on Lawson and the idea that it's plaintiff's burden of proof. Even if you go with the burden of proof on the defendant, there's not a total lack of evidence of uncollectability in this case. As the dissent points out, there's a loud silence from which comes an inference of uncollectability. Patrick LeHouillier, as part of his investigation of the case, wrote a letter to the doctor, Dr. Hughes, saying, put your malpractice carrier on notice. And there's no response to that letter, not from Dr. Hughes, not from an insurance company, not from a defense attorney. As the dissent below points out, the only inference that arises from that silence is that there was no coverage, there was no insurance. And that inference is some evidence of uncollectability, which is sufficient to put on plaintiff the burden of now proving collectability.
But why is that a fair inference? I mean, I certainly litigated cases in the civil side. I mean, lots of prospective defendants just ignore demand letters. It may be nothing more than, hopefully this goes away and I'm going to ignore this. So I'm a little bit troubled, but I think maybe Justice Samore was asking a different question. So let me try, and he'll tell me if I'm misunderstanding. I think what he's saying, what he was asking, and I have the same question. If we say Lawson didn't decide this, so this is a case of first impression, who has the burden in our view? I understand there's some other authority out there. And we say, no, for a matter of first impression, it's the plaintiff's burden. Why shouldn't we remand to give the plaintiff a shot? Your view is if we said, no, the burden is on the attorney, that would be new, so you have to get a new trial. You get a chance. If we say, as a matter of first impression, it's the plaintiff's burden, why doesn't the plaintiff get a new chance? Did I understand that?
No, that's exactly what I'm trying to get at, is why the different rules?
Because the trial court said it was plaintiff's burden of proof, so plaintiff should have addressed it in the trial court. Does that answer your question?
No, because this came up after the plaintiff's case in chief was closed, right? Didn't it?
Okay.
So the plaintiff has presented all their evidence, and their case in chief is done. And it's at that point that I think that it was brought out by Mr. LeHouillier. And so then it's at that point that the trial court decides the issue. But if we decide that this is a question of first impression that had never been addressed before, then why don't we have the same rule, regardless of what we decide in terms of a remand being necessary?
I agree with the basis of your question, that deciding a rule of first impression, saying this is a rule of law now in Colorado, a new rule of law should be applied prospectively only, or in this case, remand for new trial under the new rule of law. I agree with that. But the earlier part of your question, you said the issue didn't come up until directed verdict. Well, we raised it in the answer to the complaint. From the very beginning of this complaint, we said collectability is an issue. So plaintiff had notice from the beginning and could have presented evidence.
But the law wasn't decided. Let's assume, under my hypothetical, the law is not decided as to whether they are required to do that or not. So just because you raised it doesn't mean they're required to prove it, right?
I guess my response to that would be, once plaintiffs saw it raised in the complaint, they should have in turn raised it on their own through some kind of motion.
Well, let me follow up on that then. If you could address the restatement third, which I recognize it may be a little bit unclear, but as best as I read it, it kind of suggests if there's a collectability issue, the attorney has to come forward and then the ultimate burden rests on the plaintiff. Could you let us know what you think about that?
Sure. Sorry, a little more water.
You're going to need more water.
Keep it low so I don't spill it. As you were just saying, the restatement third creates, in effect, a rebuttable presumption of collectability. It says, essentially, with the comment B below, we'll presume that a judgment is collectible. But as the dissent in this case below points out, that's a rebuttable presumption, and it disappears in the face of some evidence of uncollectability. The silence, the absence of response to the letter to Dr. Hughes is some evidence of uncollectability. Maybe this goes back to a question you had earlier, Justice Gabriel. The idea that, why is that silence evidence of uncollectability? I find it hard to imagine that any doctor worth his salt would ignore a letter that says, put your malpractice carrier on notice. It wasn't a demand letter. It wasn't saying, give me $1 million. It said, put your carrier on notice, please. And it's hard to imagine that once the doctor contacts the insurance company is going to ignore that as well.
But do we know that the doctor didn't give notice? I guess that's the point. Maybe the doctor did notify the carrier. I mean, how do we know that? We're making a lot of assumptions.
And if he didn't notify the carrier, then by virtue of most policies, there'd be no coverage, right? Breach of the cooperation clause, notification clause. That's why they give notice immediately to their carrier, protect themselves from an argument that there's no coverage based on breach of cooperation or breach of notice.
But why do we assume, and I'm not trying to argue with them, I'm just trying to understand, why do we assume that there was no coverage or there was no notice? I mean, ultimately, where this case went, as I recall it, it's just Mr. LeHouillier decided there's no case, I'm not going to file anything. Done. If there was a case that was filed, we would expect to see an entry of appearance from insurance counsel, hired by the insurance company. But we didn't get that far. So why do we assume there's no coverage? Does that make sense?
I'm struggling with the why we assume, which is basically your question.
Yeah, you gave notice, or you said, notify your carrier, and then we've just presumed that there was no coverage, there was no carrier to notify, because we don't know if they did. May well have notified the carrier, but there was no suit ever filed, so we don't know.
Well, I would answer that in terms of the burden of proof. If you accept our argument that plaintiff has the burden of proving damages and causation, and the only way you can prove damages and causation in an action for legal malpractice based on loss of a case within a case is to show what the plaintiff could have collected from the underlying tortfeasor, It's her burden to prove collectability.
No, I understand, I fully understand that, but I just, you're assuming from the silence in response to the demand letter that there was no coverage, and I'm having trouble understanding why that's a reasonable inference. I'm not sure it says anything. We don't know whether they notified a carrier or not. That's a different question than whether they put on evidence of whether there's insurance. But I don't know why you would infer.
Based on the practice of most human beings throughout the history of time and litigation, doctors don't ignore letters like that. Insurance companies don't ignore notice like that.
Do we know that the
respond.
doctor received the letter?
We know nothing. Sorry, we know
Right,
nothing.
so I mean, there are a lot of assumptions being made to say the lack of a letter raises an inference of no insurance. You assume the doctor received the letter, read the letter, made a decision not to notify the insurance carrier, so I think you're right that it comes back to a burden question. But I think, assuming that this was unsettled, and I think, assuming this was unsettled, I guess I still don't know why, in either case, we wouldn't remand to give either your client or Ms. Gallegos an opportunity to meet whatever burden we say there would be to establish collectability or uncollectability.
Okay.
There's just the absence of a response to the letter just seems very flimsy as enough to draw an inference from what's already happened.
And I guess I would address that with the presumption that a letter is properly addressed, presumption of receipt by the addressee. If the letter is addressed properly, we assume the addressee received it. But
Do we know that it was addressed properly? We're assuming that too, right?
not assuming anything, just saying it's their burden of proof. But that's right, you're right,
Okay.
Your Honor, yes. As far as the remand for whichever way this goes, following a question that if your decision here resolves a new issue of law, i.e. that Lawson did not resolve it, should you go back for a remand for a new trial on the legal malpractice issues, or medical malpractice as well? Before anything can go back to the trial court, this case has to go back to the Court of Appeals. We raised 5 other issues in the Court of Appeals, issues that affect both liability and damages. So I'm sorry to say it, but you can't skip that step and say go back to the trial court for a remand for the retrial. The case has to be remanded to the Court of Appeals and ask them to please resolve the 5 other issues we raised. Once those issues are resolved in some final fashion, you will then have, if necessary, the shape or structure of the trial that you would have on the remand following, what the decision is here.
Did your brief mention that? Did your brief mention that? Yes, it did. Okay.
Last segment of our brief to this court said, by the way, you can't just remand for a retrial or affirm the judgment. It's got to go back to the Court of Appeals to resolve the 5 other issues. I didn't list them because I ran out of space, but there's 5 other issues.
Okay, got it.
So, and while you stopped, I'm sorry, I'm not sure that we distracted you on the restatement. What is your position as to whether we should adopt something like that, or it's the law or not the law?
I don't like the restatement, but interesting thing about the restatement, as I read it, rests upon a presumption that judgments are collectible. And the argument goes like this: why would anybody in their right mind go through the time and expense of litigation, discovery, expert witness battles, motion practice, full-length trial to get a judgment unless you know there are assets waiting at the end of the line to pay the judgment? That's just human nature, and I believe it's borne out in the practice of litigants, essentially throughout American history. People don't push a case all the way through discovery, motion practice, and trial to judgment unless you know that there's an asset waiting at the end of the line to pay the judgment. So a rich defendant, he's got property or he's got an insurance policy. So the presumption, the restatement third, mentions that notion about presuming collectibility of judgments, and I think that's the underpinning for their rebuttable presumption that a judgment is collectible. The problem is you can't apply that real-world basis assumption to what's happening in the hypothetical world of the case within the case of the trial for legal malpractice. In the trial for legal malpractice, based on the loss of the underlying case, you have the trial within the trial, the case within the case. And unless you put on plaintiff the burden of proving collectibility in the underlying case, in the case within the case of the actual legal malpractice, we don't have that crucible or hardcore test to say, oh yes, there is an asset waiting at the end of the line to pay the judgment. So what exists in the real world doesn't exist in the hypothetical case within the case unless you require the plaintiff to prove collectability.
But am I right? I think I'm right that what the restatement does is it does leave the burden of proof on the plaintiff ultimately to prove collectability if the issue is raised by the defendant. But it doesn't suggest that it's an issue in every single case unless the defendant raises it as an issue.
Okay. I know they do say it remains with the plaintiff. I remember them reading saying that it's for the defendant to raise some evidence of uncollectability, and then the burden of persuasion on collectability remains with the plaintiff throughout the case. So it goes back to the plaintiff,
Right.
ultimately. But again, it rests on the presumption that judgments are collectible, which doesn't work in the hypothetical world of the case within a case unless you require the plaintiff to prove collectability in the case within a case. You're taking a presumption from the real world and applying it to the hypothetical world where it doesn't work unless you've done what you have to do in the real world, which is find out if there's insurance or if there's assets before you go through the full battle of litigation.
I'm sorry, I guess I'm not understanding that, and it may be me and it may be early, I apologize. So I'm not understanding why it doesn't work. So we presume in the case within a case, that we've got to prove, we're going to presume it was collectible. The restatement would suggest you have to come forward, or the defendant would have to come forward with some evidence that it's not, whatever it may be, and then the plaintiff ultimately has to disprove that in the real world. Yes, it is. Here's why. There's $1 million policy. So why doesn't that work?
Sorry, I lost your
Yeah.
question.
You're saying the presumption doesn't work in the real world, and I
No,
guess I don't understand why.
The presumption works in the real world. That's where the presumption comes from. In the real world, people don't go through litigation unless you know there's assets waiting to pay the judgment.
Sure.
That presumption does not work in the case within a case hypothetical world unless you require the plaintiff to present evidence of collectability.
But you ultimately do. I mean, so in the hypothetical world, what has to happen is, in the malpractice case, the restatement would say the attorney has to come forward with some evidence that this is not collectible, this person has no assets whatsoever. Then the plaintiff has to prove, in this hypothetical case within a case, yes, there are assets. There was an insurance policy or whatever it may be. So why doesn't that work?
Okay, so you're saying that in the real world, a plaintiff would normally go through with litigation blind, totally not paying attention to collectability, unless the defendant says, by the way, there's no insurance. I don't think that's the way the real world works. Think of car crash cases. In car crash cases, the police report identifies both drivers and lists who their insurance company is. The plaintiff's attorney gets a copy of the police report, identifies the insurance company, and immediately contacts them and says, we've got a case here, notify somebody and let's get in touch. And at that point, the attorneys talk to each other, and the first thing they disclose is the insurance policy. It's going to be disclosed under automatic disclosures anyway. So from the very beginning of a car crash case, the plaintiff knows that there's an insurance policy waiting and how much it is. And then the attorney and his client can discuss, well, how much are your damages? It's going to cost this much to go through the trial. Is it worth it? We've only got this much left over at the end. But they find out collectability at the very beginning in the real world.
And that would happen in a civil case in the real world because you got to disclose it under Rule 26.
Correct.
And so what's the difference?
The difference is it doesn't happen in a hypothetical case unless you require it. In the hypothetical case within a case, legal malpractice, it didn't happen here. It won't happen unless you require it.
Well, unless the
So
case is
what you're
actually
saying
brought.
You're saying is in the real world, the plaintiff will go forward until the defendant waves a red flag and says there's no insurance. I see the presumption differently. The case doesn't go forward unless the plaintiff knows there is insurance in the real world.
Right. Thank you.
Okay?
Before you step away, would you perhaps respond to the CTLA amicus brief argument about Rule 8C and the requirement to affirmatively plead any mitigation of damages?
Sure. Rule 8C about mitigation of damages, or specifically reduction of damages, presumes that the plaintiff has already met her burden of proof, establishing all the elements of her case, including some damages. After the plaintiff establishes some damages, then the burden shifts to the defendant to plead mitigation or reduction of damages as an affirmative defense. So it doesn't come into a play until the plaintiff has established some damages. In the action for legal malpractice, based on the case within a case, the plaintiff does not establish any damages until she shows the judgment was collectible. So until plaintiff shows the judgment was collectible, there's no damages to begin with. She has not met her burden of proof of a prima facie case. She hasn't shown damages or causation, so the mitigation element of Rule 8C does not come into play.
Let me ask a different question, and I think this was in the CTLA brief. If I'm attributing something to Mr. Little, I apologize to him. I think there was an argument there that talked about that there's 20 years or some period of time to collect a judgment. That strikes me as an interesting argument. Why do they have to prove collectability today when in the real world they would have X amount of time, whether it's 20 years or whatever it is, to collect?
I'd respond to that by saying that if you place on them the burden of proof to prove collectability, they have a choice of ways to prove it. All they need is one asset sufficient size to pay the judgment that they intend to get. The best way to prove it, an insurance policy, but there's other ways to prove it. And one way would be, my brother has $1 million estate in Vail. He's going to die in 10 years. He told me he's going to give me the property in 10 years. So in 10 years, that tortfeasor is going to have $1 million of property. Yes, the judgment is enforceable for 20 years, but you can't prove damages by speculation. The plaintiff can't speculate, in 20 years I might have assets, or the tortfeasor might have assets. Plaintiff's burden to show in that 20-year period there will be a specific asset. Fine, let them do that. They have evidence to show that.
I believe your time is up.
Good morning. My name is Thomas Neville, and I am counsel for Amicus CTLA. I'm going to be presenting the argument as to the first issue on collectability and whether that's an element of the plaintiff's burden of proof. Mr. Alleman at counsel table will be cleaning up the last two issues. So with that in mind, I'm going to ask the court today to hold that the proof of a lost judgment is prima facie evidence that the client suffered damages as a result of attorney negligence, and that collectability is an affirmative defense in a legal malpractice case, which means that the attorney has the burden of proving the extent to which the lost judgment would not have been fully collectible. And I think that's an important distinction here, because collectability is not a binary issue. A jury in a legal malpractice case could conclude that the lawyer was negligent and a judgment was lost, but the judgment would have only been for nominal damages, $1. And that establishes that a $1 judgment is sufficient to prove a legal malpractice case. And if a judgment can be worth $1 up to $1 million, that means that the fight over collectability is fundamentally a fight over value. And that takes us out of the realm of an element of the burden of proof for the plaintiff and shifts this into a debate about what are the damages.
Mr. Neville, can I ask you whether you know what the practice has been in Colorado as to where the burden rests on collectability?
Well, in my experience, it is sometimes an issue, and sometimes it is not an issue. There is actually a second unpublished Court of Appeals opinion that deals with that issue, which was a case of mine. The issue of collectability in that case was also raised after the close of the plaintiff's evidence, and that then creates problems for a plaintiff who had not anticipated that collectability was going to be raised in a case. And that was a case involving mechanics liens where there was real property that was securing the value. In some cases it comes up, in some cases it's never raised.
And when it comes up, where have courts placed the burden?
In my experience, the court had placed the burden on the plaintiff, although again, it came up in an awkward timing. Beyond that, I can't speak to how courts have been addressing the issue.
So in this case, when Ms. Gallegos and her attorney, second attorney, saw the defenses and affirmative defenses section of the defendant's brief, would it have been reasonable for her to assume, or her attorney to assume, that it was being raised as an affirmative defense that the defendant would be putting on evidence about?
I certainly believe so. And I think that then the absence of any discovery, and I'm speaking in a hypothetical because I wasn't involved in the underlying case, but I would think that if it's raised as an affirmative defense, and then there is no discovery directed toward the tortfeasing doctor, that would suggest to a plaintiff that, there's not going to be any evidence on this, and since it's their burden to carry this issue, we don't have to go out and conduct that discovery ourselves, because we can rely on their assumption of that burden in the
But why
answer.
do we assume that it's an affirmative defense? You've been around a long time. You've seen a lot of defenses and answers to complaints, and many of them, as Mr. Mead says, are not affirmative defenses. They're just kind of, and some of them are long-winded, why we're not liable, and it's not an affirmative defense. Why would you assume it's an affirmative defense?
Your Honor, well, first of all, there is an issue in Rule 8 that the listing of affirmative defenses is not exclusive. So a listing of affirmative defenses can be beyond just the 19 that are listed in the rule. Second,
True, but there's an issue of the burden of proof. If it's an affirmative defense, the burden of proof is on the defendant. If it's just a defense, it's not on the defendant. It's just kind of I think you're wrong. So
the next question is, what would you do in that situation? Well, one thing to do would be to look at the case law. And if you read Lawson closely, it doesn't address the issue of who has the burden.
I tend to agree with that, but if you look at a whole bunch of case law, and you shepherdize Lawson as an old word, or insta-cited, or whatever you want to say, you're going to find a whole bunch of cases that say the burden's on the plaintiff.
Right. You will find cases that go both ways, because there are a number of cases that go the other way as well. It might be more prudent to view this as an issue that's your burden. It might be reasonable to read that as the listing of affirmative defenses to say that it is something that they are taking as an affirmative defense, because there's no reason to list it if they are simply going to attempt to negative one of the key elements of your case.
But it does happen all the time. I mean, with all respect, I did it when I was in practice, and a lot of lawyers do it. That's true, isn't it? Lots of answers just kind of, they're, what we say in the criminal world, it's a traverse. You can't prove your case. Maybe that's just for media attention, or maybe that's to make the client feel better, but it's in there all the time.
It is true that defense lawyers will list a host of things as affirmative defenses, which may or may not be affirmative defenses, but isn't a plaintiff entitled to rely, at least to some extent, on the representations that are made in that answer?
Well, if it's an affirmative defense, yes.
And in Rule 8C, it says any matter constituting mitigation or any circumstance that would constitute mitigation or reduction of damages must be affirmatively pleaded.
All right, can I ask you one more question, just relating to where you started? And first of all, I apologize to you. I think I gave Mr. Little credit for your brief, and I'm sorry to both of you. As I understood what you said at the beginning, you said once you've proven a duty and a breach and causation, essentially that establishes nominal damages, and then the burden should shift to them, if I heard you right.
It's not actually what I said.
Okay, then
And
try
that's an
again.
important distinction that I tried to make.
Okay, my apologies.
Lawson says that you can't prove nominal damages in a legal malpractice case. That's actually one of the things that they hold. What I am saying is that if the jury concludes that the lost judgment would have been for nominal damages, then that lost judgment has a value of at least $1. That's an actual damage in your legal malpractice case.
So how does that get presented to the jury? And did that get, go ahead.
Well, so in that case, the jury in the legal malpractice case conducts its case within a case analysis. And it concludes what was the lost judgment. And whatever that lost judgment is in the legal malpractice case, that's prima facie evidence of the plaintiff's injury.
But was the jury in this malpractice case ever asked that question? I think that you want us to presume that the jury necessarily would have found at least the nominal damages, I guess, based on the fact that there was a judgment, but they were never asked the question. They were never told it's the plaintiff's burden to prove collectability or anything like that, or that there's a prima facie case.
Right. And so let me I'm going to try and answer this question, but it might take me a moment to get to the answer you're looking for, which is, in Colorado law, we treat judgments as prima facie evidence of damages in many different kinds of cases. In the legal malpractice context, we treat a judgment on the case within a case as a presumption of that the client suffered damages up to the full amount of the damages when it's a defense lawyer who commits malpractice. If it's a plaintiff's lawyer in a contingent fee case, that's the only time that collectability might be a question as to whether there were any damages. Because an hourly client will have paid an attorney for their time and will have come out of pocket for damages. And even a contingent fee lawyer will be advancing costs, perhaps, or will be passing those costs on to a client. So if the question is, does the plaintiff have to prove any damage to prevail, I would submit that the issue of collectability as to whether that's an element of the case in chief will only arise in a very narrow subset of cases, and that in every other case, it's going to be easily handled by fees, costs, what have you, and that in this rare subset of cases, we should continue to view the judgment that was lost as evidence of what the value is of the lost judgment. Then, at that point, the defense can come forward and say, yeah, sure, you got a $5 billion judgment against a homeless person. You wouldn't have received all of that. But by showing the lost judgment and its face value, the plaintiffs carried the burden of showing that there was an injury and establishing that there is some value to that. And so that suffices to prove the case. Does that answer the
Yeah,
question?
you did, thank you.
Can I jump in here? In this case, when they raised it at directed verdict, what was the response? Was it, I thought it was an affirmative defense, they pled it? I mean, is there any indication of prejudice or reliance?
Your Honor,
That,
that's probably a question that's better directed to Mr. Alleman, only because I'm focused on the larger legal framework, the question of law here. As to the factual issue,
I will keep my powder dry, as they say.
Sorry.
All right.
what I can say, though, is that there is good evidence that is of the same vintage as the Lawson case that suggests that evidence of the face value of a judgment is prima facie evidence of the value of that judgment. That's Hershey v. People. It's the negligent escape case. And it says that a creditor is entitled to recover only those damages that he has sustained, only actual damages. That prima facie, the amount of the damages is the amount of the judgment against the debtor. And that the defendants are entitled to prove, if they can, debtor's poverty or insolvency in mitigation of damages. And fundamentally, that's consistent with Rule 8C. And Colorado's Rule 8C merits some discussion because it is unique in the United States. It is the only Rule 8 that provides that any mitigating circumstances to reduce the amount of damage shall be affirmatively pleaded. That doesn't exist in any other state. And what that means is that the defendant lawyer can say, yes, plaintiff should have received a judgment. And yes, it should have been what the jury concludes the value of the judgment was in the case below. But plaintiff would not have received the full face value for reasons A, B, and C. That essentially is a confession and avoidance. It is, yes, your facts are all right, everything you've pled is true, but even so, my liability is less. That is fundamentally what an affirmative defense is. Lawson, coincidentally, addresses the issue of how do you prove a negative, which was a concern of the defendants. And the way you prove the negative, that nothing would have been collectible, is you introduce evidence of the insolvency of the tortfeasor, because that then creates the continuing presumption that that there was no money to pay any judgment over the life of the judgment, which isn't just 20 years. It's 20 years unless it's renewed for another 20 years and so on. There are a host of reasons to place the burden of raising that a judgment would not have been collectible in part or in whole on the defendant. The first reason is if the issue of collectibility falls on the defendant's side of the ledger, then the defendant gets to control when and whether a third party gets dragged into litigation. This situation isn't always going to arise in the case of a neuroradiologist or a professional who presumably has some assets. If collectibility needs to be proved in every legal malpractice case involving a lost judgment, that means every conceivable defendant out there in the underlying tort case can be hailed into court and asked to give up their private personal information to a plaintiff to prove this collectibility. They're going to have the opportunity to resist that and say, look, no, you can't get into my finances. And this court has said that we all have a constitutional right of privacy as to our personal finances, which means that you're going to put trial courts in a position of having to balance the interests of a non-party against a plaintiff or a defendant lawyer, a client or defendant lawyer, and decide how much can we really find out about this individual's financial situation.
Doesn't that problem apply regardless? I mean, whether it's your burden to prove collectability or theirs to prove uncollectability, that third party's in the same boat.
Not necessarily, because the defendant can make the first shot. By making it their burden, they get to decide. They can say, well, there was insurance, and so it was only collectible up to $25,000 if it's a car crash case. That's the minimum limit. There was a policy with $25,000. That's the bare minimum. That doesn't involve delving into somebody's private personal information.
But if they have to prove the negative, I mean, I could see it's a case where there isn't any insurance, then you're really getting into somebody's assets, as opposed to on the plaintiff's side, you put on the insurance policy and you're done. I mean, there seems to be more of a risk if the burden is uncollectability of getting into someone's personal assets than the other way around, but I could be wrong.
Well, I think that the problem here is that collectibility is not a binary. It is not collectible. It's to what extent is collectible. So if you put the burden on the plaintiff is going to have to address, well, what about bankruptcy? That's an easy thing to raise in defense. Oh, they would have gone bankrupt. Well, now we got to have a case within a case with a bankruptcy trial on the side, which increases the burden on the plaintiff. And it's a burden that appears in every single case.
So can I ask, related to that, how often do you think collectability is an issue in a legal malpractice case? And I'm curious what you think of the restatement rule, which I, as I understand it, the restatement says the defendant has to raise that collectibility is an issue in the case, but the plaintiff then ultimately has to persuade as to collectibility.
I'm going to answer the second question first.
Okay.
And the reason I'm going to answer the second question is I think that ultimately supports the notion that it's an affirmative defense. The plaintiff proves their case within a case. They prove that there's a lost judgment. The judgment has some value, right? We argue that the face value is the value, and then the defense says, well, hold on, you wouldn't have gotten it all. They've raised this as the affirmative defense. At the end of the day, the plaintiff still retains the burden of proof as to damages. What is the extent of the injury, right? If they prove that there was no way anything would be collectible, it's a complete defense. If they prove that it was only collectible up to, well, then the evidence is in front of the jury. Was it collectible up to $25,000? Were there other assets beyond that? Was it collectible up to $1 million? But now we're arguing about the amount of damages, not the existence of damages.
Okay.
As to the first question, collectibility is unlikely to occur in your typical car crash case.
Except if we hold as your opponents would like us to hold, it will always be an issue. Is that part of the concern? If we say that the plaintiffs bear the burden of collectibility, that necessarily becomes an issue in every single
Yes.
legal malpractice case?
It will, because we'll have to prove it. Now, some cases it may be easy. If the defendant is AT&T, right, you can say, well, it's AT&T. They're a Fortune 100 company. They have a lot of assets. It was going to be collectible. But there are other cases where that's going to be a much harder fight, and it's going to have to involve getting into somebody's personal assets and, having that extra bankruptcy side to your legal malpractice case. Because we have to prove every possible way that could have been addressed, or to preemptively avoid all of the potential defenses because it comes into our case in chief. There is one thing that I'd like to note. The Court of Appeals listed a host of reasons why other courts are placing this burden on defendants and making it an affirmative defense. There was a statement that defendant made, or defendant's counsel made, that, if there's insurance, plaintiff's lawyer is going to send a demand letter or something to an insurance company, and they're going to know how much that case was worth. That's not how it works. In reality, when you represent somebody in a personal injury case and you send a letter to an insurance company, certainly in a car crash case, the response you get is, yes, they're insured. And we don't find out the policy limits. More and more often, you have to file a lawsuit to actually find out your policy limits. So there is not an easy way to find out the extent of the insurance policy in the absence of filing a lawsuit. Also, you have to then assume that even if the insurance company does provide some information about the policy limits, that makes it into a lawyer's file and is retained to the time of trial in the legal malpractice case, which in some cases, that may not be the case.
Can I take you back just a minute? Just a very fundamental sort of problem that we've all been talking about here. I appreciate at least part of your argument about the $1, I think. But conceptually, a tort case, you've got to prove that you were injured.
Right.
And so in what way is it not taking away one of the elements of the case to not require the plaintiff in a malpractice case to prove that he was injured?
I think that proving that you've lost a judgment proves that you've suffered an injury. Judgments are kind of unique in that they come with a face value, a number that a jury has concluded your injuries are worth. And so the judgment has a value that is at least $1 and maybe up to that face value. So you have the burden of proving that you've lost something of value, and you've proven that you've lost that judgment.
And so would it be fair to say that all of the series of arguments made, however we were to parse it out, even the restatement, creating presumptions, all of it depends on an initial assertion or acceptance that the judgment itself is the injury?
Yes, the lost judgment is the injury. And that's consistent. It's consistent with People v. Hershey. It's consistent with, more recently, Nunn versus Mid-Century. It's consistent conceptually with the defense legal malpractice case. In Scognamillo v. Olson, we have the notion that if your defense lawyer commits malpractice and a judgment enters against you, we're going to say that the measure of your damages is what that judgment is. You don't have to file bankruptcy because you got a judgment, so we're going to just treat that judgment as the measure of your damages. And in Scognamillo, it gives the defendant lawyer the opportunity to raise the failure of the client to settle the case, or the ability of the client to settle their liability short of the face value of the judgment as a way to bring down those damages. In Miller versus Byrne, which is it's not an easy case to fully wrap your brain around because it's got bad faith issues and legal malpractice issues. Ultimately, though, the injury to the defendant client, or the client defendant, is based on whether the failure to get the case settled caused an injury, and that depends on what the judgment would have been in the wrongful death suit that ultimately settled short of trial. But we treat those judgments as having a value in these contexts. And so it's entirely consistent to say when you prove your case within your case, and you say you have lost a judgment, to say that's the prima facie evidence of the value.
But if that judgment was ultimately not collectible, how is the plaintiff then harmed by the lawyer's failure to obtain that judgment?
The lawyer is harmed to the extent that the judgment was not collectible. If it was only say it's $1 million judgment, but you can only get the guy to pay $100, then your damages ultimately are only going to be that $100. The problem is in treating collectability as an element, what you're saying is that we're going to assume that the judgment has no value at all unless we open the door into the tortfeasor's assets.
Well, I'm not sure, are we really saying there's no value to the judgment as opposed to saying there are no damages if it's not collectible? I think those are different things. I mean, you can get a $1 million judgment that is valueless if the defendant is penniless in terms of damage. I don't want to use the word valueless. It is not evidence of the damages, is what I suppose you're saying the judgment is a presumption. It is presumed collectible, is what it really leads to. That we start from the presumption that $1 million is collectible, and then it's on the defendant to prove that it's not.
Correct, and that's consistent with Lawson. Lawson says, look, if they're insolvent, you never would have gotten the money. So that's a complete defense.
But why isn't that, and coming back to the Chief's question, why isn't that just evidence of causation and damages if you couldn't have collected? That should be traditionally on the plaintiff.
Because to take that presumption, you're saying that the value of that lost judgment is zero to start with.
Not presuming anything, you have to prove that you would have gotten it.
Then you are putting a burden on a plaintiff to, in every single case, go through the myriad different ways that you could have tried to collect it, and preemptively cutting off arguments for why they couldn't. It greatly magnifies the scope of the litigation and the burden on the plaintiff when the defendant may concede that point down the road. So it just makes, it unfairly increases the cost and expense of litigation and the amount of time that goes in, and it increases the odds that people who shouldn't have to pay lawyers to keep their private information private are going to be pulled into court to do that.
At the risk of insulting you, we did want to hear from Mr. Alleman too.
Good morning, Your Honors. Jason Alleman, number 42570 for the respondent, Della Gallegos. I did want to answer, Justice Gabriel asked if the jury was asked to actually determine the money damages and whether or not those would have been recoverable. That was instruction number 33. In this matter, the jury was presented with this instruction. The plaintiff, Della Gallegos, has the burden of proving by preponderance of the evidence in the absence of negligence by the defendants that she would have obtained money damages against Dr. Hughes in the underlying medical negligence case and what amount she would have recovered. So that was an issue that was asked of the jury to determine. And as the court knows, the jury did determine, based on the evidence, that the judgment would have been collectible from Dr. Hughes. And that's the first issue that I want to address, if I may, is whether Ms. Gallegos provided sufficient evidence that the underlying judgment was collectible. And of course, the court does not even need to reach this issue if it affirms the Court of Appeals decision that Ms. Gallegos did not bear that burden. Nevertheless, assuming that Ms. Gallegos bore the burden of proving the collectibility of the judgment, the trial court correctly determined that Ms. Gallegos presented sufficient evidence. Pursuant to Morris v. Gear, a plaintiff can meet the burden of proving causation and damages in a legal malpractice claim through circumstantial and direct evidence. Here, the evidence presented to the jury that Dr. Hughes was a medical doctor with a specialty in neuroradiology employed at Memorial Hospital at the time he missed Ms. Gallegos' MRI or misinterpreted it. Also, it is undisputed in this matter that defendants believe that Dr. Hughes was solvent at the time he agreed to take plaintiff's case, and there was never any evidence presented at trial that Dr. Hughes, in fact, lacked insurance or lacked or had financial problems or lacked the assets to cover the judgment here. Another important fact that was brought up was pursuant to CRS 1364-301, a doctor is required in Colorado to carry $1 million worth of coverage. And according to the New York Life Insurance Company claim, because the presumption is the statute was complied with, the trial court did not err in finding that the statute created an inference that Dr. Hughes had sufficient coverage to cover the judgment. This presumption of insurance was never rebutted by the defense during the trial. Accordingly, the trial court correctly determined that Ms. Gallegos presented sufficient prima facie evidence under Rule 50, and enough evidence to allow the jury to infer that Dr. Hughes would have carried malpractice insurance as a practicing doctor or would have had the assets to pay the judgment. The jury in the matter was authorized to consider the evidence as well as their common knowledge when reaching a verdict. And based upon the evidence presented and the common knowledge that most medical doctors carry liability insurance, the jury was permitted to infer that Dr. Hughes had malpractice insurance.
So you're going to run out of time, so you have to jump in. Go ahead, Chief.
No, it was so you
Justice
don't want to
Barrett.
defer to me? No, go ahead.
What? I defer to my senior colleagues.
Oh, okay.
Yeah.
So did you even object to the shifting of the burden then? That's what was my question earlier. At the motion for directed verdict?
I believe if you look at the record, Mr. Hemmett did make an objection or some conjecture about, well, I'm not sure he even has a burden here. And that was a topic of discussion by the trial court as well. So that this was an issue that was correctly preserved. And I do not believe that anybody in any of the briefing claimed that this was not an issue that was properly preserved on both sides.
All right.
Go ahead. Oh. Well, if we disagree with you on proof of collectability, as the Court of Appeals did, or that she provided proof of collectability, and we disagree with you on the big ticket item as to whether it should be part of the plaintiff's case, address the issue that we batted around earlier, what I characterized as sort of the gotcha quality. It seems particularly unfair if we decide that Lawson didn't resolve it as an issue of first impression. So how should we handle this if we say it's an issue of first impression and you weren't on notice? Should we remand for a new trial, or should something else happen?
I would certainly request that would be remanded for a new trial. Because here there was never any sort of evidence presented at all that Dr. Hughes was insolvent or would not have been able to carry the judgment. That was something that the defense never presented, even though they presented it as an affirmative defense. I know they wanted to mince words and say, well, it's defense. But I think if you look at the answer itself, I think it's very clear it's listed as an affirmative defense. Also, I think if you look at it in an equitable standpoint, because they listed it as an affirmative defense at the beginning, they should have bore the burden of presenting that evidence. Also, they were aware, they should have been aware of the cases that Mr. Neville cited, such as Hershey and Levin and Miller and all those other progeny of cases that have come out that basically have stood for the presumption that a judgment in and of itself is an issue of damages. I see that my time is out. I thank you, Your Honors. I'd ask that you affirm the trial court's verdict and judgment.
Thank you. Appreciate the arguments of both counsel. The case will stand submitted, and I think we'll move on to our next case, which is styled Allen versus the State of Colorado and others. Everybody looks at counsel for the, I guess we have a direct appeal here. Counsel for the appellant.
Thank you. Nathan Kiva for the appellant, Sam Allen. You're asked here to determine if the water court has jurisdiction over Mr. Allen's claim of an inverse condemnation of his mutual ditch rights. Or is this some sort of exception to the Cobabel ruling, which said that, in fact, the water court will handle inverse condemnation actions of water matters. Our position is that this case fits right into that. That is the claim here, is that it's an inverse condemnation of a mutual ditch right, which is a water right.
Well, I'll jump right in. Is it Cobabel, I guess is how you pronounced it. Isn't that case different? There's a cease and desist order to prevent someone from pumping water. That strikes me as a direct attack on the right to use water. And why isn't that different than the issue here of who owns ditch shares?
Ownership of water rights is always a question of what you can use the water for, or what the scope of that water is. A mutual ditch share is simply your recognition of the fact that you have a right to use that water for a particular spot. Here, the Court of Appeals said you cannot any longer transfer that water right to another piece of property. You cannot transfer that water right to somebody else. That was a limitation on that use. It now runs with the land. Our position is that's different than what the state of the law was at the time, and that makes it an inverse condemnation of the water right.
So what's the limit to your argument? I mean, it seems to me, from if I understood you, basically any ownership of water right necessarily relates to the right to use. Therefore, the water court has jurisdiction over any matter relating to ownership of water, period, which seems to undermine what Cobobel and other cases talk about in terms of the distinction between use and ownership. Your argument seems to eliminate the distinction. Ownership always means right to use, unless I misunderstood you.
I think the distinction is still there from the Humphrey case. Humphrey says that if this is an argument about private agreements, and we're interpreting private agreements, the district court can still handle those matters, and does handle those matters. And so that's a different question. And the question that came up in Cobobel was, what are we going to do with inverse condemnation? Where does it fit in this system? Well, it's not a private agreement situation. The question is, did the state do something? Did the state act in some way that limited this water right? The decision was made, okay, these are water matters, and therefore that's different than these matters that deal with private agreements.
But the nub of the takings claim in that case, Cobobel, really did hinge on the use of the right, the use of the water itself, the pumping of those wells. And here, and I'm just sort of piggybacking on Justice Gabriel's statement, what's at stake here is the transfer of the ownership of these shares. That's an ownership issue, is it not?
Well,
Simply-
all that shows is that, okay, not only can't you not use it or ratchet it down, if you will, in the cease and desist because of the finding that you were out of priority, but you can't use it at all. So it's just the completion of the taking as opposed to
you can't transfer it.
as opposed to a partial ratcheting down of the right. They're saying you can no longer utilize that right the way you could before.
Well, you can't transfer it to another owner separate and apart from the land itself. It can't be conveyed separately. That's the concern, right?
Well, that's no longer an issue. I mean, that has already been decided that it will not be. So that isn't an issue for this water court to now decide. So that's why it's outside of the question of ownership. The ownership's been decided. The question is state action. Was that state action a taking? That's what the water court's left to decide. And Cobobella says, we're going to view this as water matters. And it makes sense. Did you have a question?
No, it's fine.
Well, isn't the difference that in Cobobel, they were looking at, the well owners were seeking compensation for the loss of their farming operations based on the loss of water, right? Isn't that right?
Right.
And in this case, it's compensation based on the conveyance of the water rights to the buyers, isn't it? It's not based on the use of water, it's based on a conveyance, isn't
That's
it?
exactly why this belongs in the water court, is because that valuation is based on your use. Had this decision not been made, Mr. Allen could have taken that water and used it on other property. Based on that decision, he can no longer use that water. So
Okay,
the question
I
or
am
the
gonna jump in.
valuation.
I just don't understand, I don't understand how you're not just conflating use and ownership. I mean, the reason he can't use it is because he doesn't own it, right?
Well-
He can't do anything with it because it's not his. Isn't that an ownership question?
I think that the difference is, what decision does the water court need to make? Does the water court need to make an ownership decision here? And if the water court needed to make an ownership decision, or if the court needed to make an ownership decision, then we could look at it through private agreements. Then we would look at the district court to make an ownership decision. Here, there is no ownership decision to make. The question is state action. Was the state action a taking? Was this use of the water taken by inverse condemnation? So that's the question that's left for the court below, be it a district court or a water court, to make. And Cobabel said inverse condemnation is going to be a water court, because we're not questioning ownership anymore. That question's off the table.
But why are you discussing, I mean, I guess I'll turn it around on you. I understand what you're saying. Ownership has been decided already, but so have water rights. So what water rights issue is the water court going to be asked to decide here? The question comes down to who owns these shares. I have the same concern as Justice Hart. It seems like you, in your view, ownership always means use, ownership of these shares, and so the water court always has jurisdiction. I think I started there too. I'm not understanding distinction, and maybe I can ask you to address 742-104, which says shares of stock are personal property. Doesn't that inform the analysis as to whether this is an ownership question?
Well, the first part is the question of whether ownership would have to be decided. Ownership has already been decided, so it isn't a question before the court to determine. The question is just state rights or state action. The question about the Ditch Act is our claim that that is the state action that went too far. The Act said these are personal property, and these are encumbered by the bylaws of the corporation, which in this case and in all cases for mutual ditches is writing on the shares that you've encumbered them. Here, there was a decision made that said, well, for Sam Allen shares, they're real property, and you don't have to write on them. And Mr. Allen, transfer your shares. We're going to say they're not freely usable by you. Transfer them from Party A to Party B to benefit the land trust. That's the state action that the water court has to look at. Those are water issues. You know, what do you do with the mutual ditch under the Mutual Ditch Act? What do you do with these mutual ditch shares? Did the state action infringe on that water right? Under Cobabel, that's all a question that the water court can best answer. It's not private agreements that we're looking at. None of those questions are private agreements. They're legal questions regarding water statutes, and they're questions regarding mutual ditch shares, not private agreements as to who owns the water.
So you're sort of effectively doing this, but can you list all of the reasons that you can think of that it makes more sense to have a water court resolving this as opposed to just the district court? The reason I ask is I think they're good arguments in both directions on this use ownership distinction. And so ultimately I just find myself thinking, well, where should we want this to be litigated? And you're saying in part we want it to be litigated in the water court because of things like the Mutual Ditch Act. You've talked about in the brief about valuation involving historic consumptive use. What else?
Well, I think you start with the statute, and the statute said water matters are going to be in water court, and the water court's going to handle that. And then Cobabel, which says inverse condemnation is a water matter, and then the reason it's useful is the water court has the ability and has done these types of things to look at the value. At some point, you're going to have to figure out, okay, what was the value that the state infringed on? And you determine value of water rights by priority. You determine it based on how you use it. You know, how the farmer puts it to use or can no longer put it to use. Those are all questions that a water court deals with all the time. And so that's why it makes sense, and it made sense in Cobabel to say water court's the best place for it.
Can I ask you a question about Cobabel and maybe we've already plowed all this ground, but I'll phrase it in a slightly different way, rather than coming at it from the other side. And that is, in Cobabel, I guess we'll call it Cobabel, is there a difference between a determination not that you lack the water right, but rather that there's simply no water available for you to draw it, to use it at this particular point in time, and that's what the issue was about depriving. That is, was there, I believe in Cobabel, there was not any issue about whether the appropriation belonged to the party claiming or the, in a sense, the right to that appropriation, to that decree, whatever, to that amount of water. It was a determination that that water was not available because it belonged to other people. And that was the determination that we said was for the water court, was it not?
No.
Not a question whether the well owners actually had a water right.
No, that was the second issue. The first issue is which court should make the decision. And that question was answered in the water court should make the decision of was there a taking? Was there an inverse condemnation? The water court in that case said no, there was not an inverse condemnation. And this court upheld that yes, the water court should make that determination, and upheld that in that case there was no taking.
And maybe let me rephrase then. I'm not disagreeing with what you're saying, I think. I guess what I'm asking is there a difference in the nature of the taking? If the claim of taking is because there's been a determination that there's no water available for you, is that different from a claim of taking as a result of a determination that you don't have the right?
I guess because of the nature of a water right that is based on its use, there is really no difference there, in the sense that if the state has infringed on your ability to use, or if the state has infringed on your ability to use it to the point where, 90% or 100%, then that's been an inverse condemnation and therefore taking, and therefore water court should decide that.
And let me just rephrase one last time, because we're getting right down to the point that I want to make here. Is the question rather in Cobabel, the determination of the water court was whether you have a right to use or not? And they were determining that the well owner in that case did not have a right to use. And that was what they had authority to decide, not the question whether he was the owner of that right.
Well, the question was, the state had already taken the position that they had no right to use. And so what the water court was determining was that a correct assessment by the state? And did that in terms of an inverse condemnation action with jurisdiction. So what they were doing was saying, yes, that was correct, and therefore not a taking, or no, it wasn't correct, and therefore a taking.
Okay, thank you.
Thank you.
May it please the court, counsel. My name is Pat Sayas. I represent the state defendants in this case. I'm here with Paul Bennington, who represents the chief engineer, and Mr. Peter Nichols with Conservancy. They're the co-defendants in this case.
And maybe you could just let us know, are you all planning to share time in some way? Or?
Mr. Nichols and I plan to share time if there's any left. Mr. Nichols is going to react to the issue concerning Mesa Conservancy. I appreciate it. Our position is that the water court got it right. It got it right in its order when it ruled that it did not have subject matter jurisdiction in this case. And even if the water court got it wrong and somehow it did have jurisdiction, this is not an inverse condemnation claim. In terms of the Colorado Court of Appeals decision that gave rise to that claim is not an inverse condemnation claim. Now, you've talked about Kabobel. I'm going to call it Kabobel, okay, because that's what I've been calling it. So in Kabobel, what you had was an inverse condemnation claim, admittedly, and we have one here. But that's where the similarity ends, because in Kabobel, it was about, and I think you hit it on the head, it was about use of water. Why? Because the farmers in that case, they owned the wells. The issue was whether they could use them, and that was set against the backdrop of the prior appropriation doctrine. First in time, first in line. So it was about use. Here, what we're talking about is the ditch shares, and the issue here is who owned the ditch shares. Why do I say that? Well, we look at the facts. Mr. Allen purchased the property from the United States government, and there was a conservation easement attached to that property. And the easement provided that the water rights, those ditch shares, go with the property. Mr. Allen sought to sever those ditch shares. Why? Presumably to retain ownership of them. Why? So that he could sell them, presumably at some subsequent time. So it's about ownership. In the water court, they recognized that. And we submit that the water court was correct when they characterized the nature of Mr. Allen's loss as being the loss of ownership of the ditch shares. That's what he lost. So that's one of the differences between Kabobel and the facts here, because Kabobel clearly was on about use. Could the farmers use their water? And the determination was that they could not. Here it's about who owns the ditch shares. Does Mr. Allen own the ditch shares as he claims, or was the Colorado Court of Appeals correct when they said no, Morton Stevens, the people who own the property now, own the ditch shares? So it's about ownership. Now, Kabobel also, just as a point, nowhere in that decision did this court say that anytime you have an inverse condemnation claim that even remotely is about ownership of water rights, that automatically falls within the jurisdiction of the water court, not the district court. Because as we know, the district court, that's their jurisdiction. And nowhere in the Kabobel opinion did this court say that the water court has the right to review a Colorado Court of Appeals decision. Because ultimately, that's what Mr. Allen's asking the water court to do. Now, Mr. Allen has made clear that, no, I'm not doing that. What I want the water court to do is give me the just compensation that I believe I have coming for the alleged taking of my ditch shares. But you can't decide that in a vacuum. Someone, presumably here, under Mr. Allen's theory, the water court would have to make that determination. And in so doing, they would have to say that no, the Court of Appeals, the way that they applied the law and the way that they interpreted the law, in effect, was a taking. That's not the jurisdiction of the water court. So the water court judge, he got it right when he said that this is about ownership. It's about ownership, not about use. So for that reason, we would ask that the water court's order be affirmed. Now, I feel compelled to touch on this notion of inverse condemnation, because we submit that there is no inverse condemnation here. Because when we talk about inverse condemnation, we got to make clear Mr. Allen's phrasing this as a judicial taking, and he relies on stop the beach for that notion. And as we've submitted in our briefs, our reading of stop the beach is that it was a plurality decision of 4.
Mr. Sayers, if I can ask you, you make a compelling, forceful arguments in your brief on this issue. Is this issue even before us? I mean, aren't we limited here today about whether there was subject matter jurisdiction? And
We submit that that's it. That's what the issue is. I only addressed it because it's our position. Even if you were to find that, in effect, the water court had jurisdiction, there would be nothing to decide because there is no taking. And our position on that is that stop the beach is a plurality decision. And under the facts of this case, you don't have a judicial taking, because what the Colorado Court of Appeals did was take the facts of the case, apply it to existing law, and admittedly, in a matter that was adverse to Mr. Allen, and in so doing, you don't have a taking. I'm going to cede the remainder of my time to Mr. Nichols, who's going to address an issue important to the Conservancy. I thank you for your time and for your attention.
Good morning. If it please the court. With the court's indulgence, I'd like to provide a little context for this. This is not just about 9 shares of water in a ditch company. It goes to the heart of the integrity of conservation easements that conserve 2.5 million acres of Colorado. These lands and water rights were conserved for public benefit, primarily with public dollars provided by Great Outdoors Colorado and the Conservation Easement Tax Credit. And that's why there were 22 amici in the previous proceeding before the Court of Appeals, including Colorado's Department of Natural Resources, Great Outdoors Colorado, and Colorado Parks and Wildlife. Colorado Parks and Wildlife encouraged the federal government to grant this conservation easement involving these water rights to Mesa Land Conservancy because it protects critical elk winter range. These water rights were used on that ranch before the conservation easement. They were used on that ranch while the federal government owned them. They were used on that ranch while Mr. Allen owned them, and they've been used on that ranch ever since. They were used this summer on that ranch until they ran out. It's the only legal place where those water rights can be used because of the conservation easement that encumbers their use specifically to that land for that public benefit for the conservation easement. So the controversy cannot be about use because Allen has no right to use this water anyplace else. You know, as you know, I'm sure, 3792-2031 sets forth the jurisdiction of the water courts. And it says the water matters shall include only those matters which this article, Article 92, the Water Rights and Determination Act of 1969, and any other law shall specify to be heard. A quick review of the Colorado Revised Statutes reveals there are 38 references to water court. There are 25 references to water judges. None of those statutes grant authority to the water court or the water judge over inverse condemnation, over the Ditch and Reservoir Act, over which Allen relies, or over the Court of Appeals, except as an ancillary matter. So for the water court to have jurisdiction here, there would have to be a water matter, and this would have to be ancillary to it. The water matter, of course, would have to involve use. This is the 4th or 5th court to consider Allen's attempts over the past 10 years to circumvent a lawful conservation easement to obtain a private benefit, private windfall at the public's expense. Allen's been pursuing his goal by reframing this issue around the conveyance, including the Ditch and Reservoir Act. The Court of Appeals decision in the previous matter made it clear that the underlying controversy is a dispute over title, transferability of title, not the use of the water. As a practicing water attorney, I have about 75 open cases throughout the state of Colorado. And I'd like you to keep, and hope you will keep, judicial economy and efficiency in mind as you deliberate.
Well, let me jump in there. So this seems like a good time to ask you about the concern I expressed earlier. If there are good arguments going in both directions, then why not just park these kinds of cases, however you want to label them, in the water court, because the water court has the expertise to be able to resolve it, whether it's ultimately characterized as use or ownership. The water court is just familiar with what's going on in these kinds of cases. And I understand here you don't want to provide them with the opportunity to circumvent, in a sense, the authority of the Court of Appeals. But as a general proposition, doesn't it make more sense to have these in water court?
With all due respect, Justice Hood, I think the expertise really lies in the district courts to deal with these kinds of ownership issues, not with the water court.
Okay, help me understand why.
They deal with, water rights are real property rights, as you know. Water or district courts deal with disputes over real property. They deal with real estate issues, and they have expertise in determining ownership issues. The reason I think that this would be inappropriate in the water court is that the Ditch and Reservoir Act doesn't provide authority to the water court to consider these kinds of things. A quick look at the Secretary of State's website yesterday, there are hundreds, literally hundreds, of ditch and reservoir companies in the state of Colorado. In my experience, every one of these has at least 10 shareholders. So we're talking about thousands and thousands of shares. I'm not sure that you want to burden the water court with that because they don't really have a lot of expertise. They have dealt with this in issues in the past when it is ancillary to a water use issue, but they don't typically deal with this on a regular basis. It is the district courts and district court judges that have this expertise as a result of dealing with real estate, other real property issues on a regular basis involving transfer of property.
And as a practical matter, if I'm understanding you correctly, water courts would become mired in litigation that might unfairly tax them, given their other responsibilities.
I think that's a good summary of our position. You know, in a couple of the divisions in which I'm active, Divisions 2 and 3, the water judges also have criminal dockets, and their water docket is a problem for them in terms of keeping up with the deadlines in terms of their criminal dockets. You know, I've got a 5-week trial right now that I'm trying to get settled in Division 2, and the judge is really pushing us hard to be able to do that, pushing us towards mediation. I think we're going to get there because he's really backed up with some problems he's got to meet with in terms of deadlines under his criminal docket.
Thank you.
So we'd urge you to maintain, support the decision of Judge Boyd in Water Division 5 and affirm the dismissal of this action. Thank you very much.
Mr. Keever, you have a little time?
Point out first that they rely on this idea that there is a controversy here about who owns the water, to keep calling this an ownership issue. There is no controversy. The water right no longer is used by Mr. Allen, nor does Mr. Allen claim he should get it back.
But he does claim that he should get some money for being deprived of ownership.
It was taken from, he owned it at one point in time, but in every takings case, you're going to have somebody who had a right to it and it was taken away. The state said you're going to take it from party A and bring it over to party B. I mean, that is a takings case. And
Right, but it's the question of you're going to take ownership from party A and give ownership to party B, whereas in Cobabel, the question was, you own these wells, you just can't use the water in them.
well, here it is, you can't utilize any of your right as a water right. That's why the water court is the right place for this, because the water court understands how these are not just ownership issues, these are use issues. And the idea of you're going to balance the water court versus the district court, Judge Boyd is a district court judge as well, as all water courts are, and so all you're doing is shifting something from one part of the docket to another. You're not clearing the docket, you're not taking anything off of it, it's just coming back before a district court judge in another forum.
I think your time is up now.
Thank you.
Thank you. We appreciate the arguments of both counsel. Case will stand submitted, and the court's going to be in recess for 15 minutes. Please be seated. Next argument on our docket is State of Colorado and the Department of Revenue versus Medved. We've set this for 1 hour, so it'll be 30 minutes to a side. I'd like to point out that Justice Boatwright will not be participating in this case. Otherwise, everybody looks set. Petitioners, when you're ready.
Thank you, Chief Justice Coates, and may it please the court. I'm Assistant Solicitor General Grant Sullivan. With me is Senior Assistant Attorney General Noah Patterson. We represent the Colorado Department of Revenue. The issue in this case is whose tax return filing triggers the statute of limitations for the department's review of a conservation easement tax credit. Is it, as the department contends, the person who actually donates the conservation easement and applies for the credit, or is it, as the Court of Appeals held below, the first filing transferee of the credit? Now, to answer that question, I'd like to focus primarily today on the statutory language at issue in Section 522, and then if time allows, touch on agency deference. But if the court has any other questions on other subject areas, I'm of course happy to address those. So turning first to the statutory language, I'd like to walk through why the department's statutory interpretation is most consistent with both the General Assembly's intent and with the plain and ordinary meaning of the text. So if we hone in on the language in Section 522(7)(I), it gives the donor expansive authority to control all aspects of the conservation easement credit. It states that the tax matters representative, or the donor, shall be responsible for representing and binding the transferees with respect to all issues affecting the credit, including but not limited to the charitable contribution deduction, the appraisal, notifications and correspondence from and with the Department of Revenue, audit assessments, assessments or refunds, settlement agreements, and the statute of limitations. Now, in the department's view, this language means that the transferees, the entire team of transferees, is subject to the same statute of limitations as the donor. And that means the same commencement date and the same expiration date. Any other interpretation, in our view, just doesn't give full meaning and effect to the strong language represent and bind in the statute. And in fact, that's what the very next sentence in the statute indicates. The very next sentence, the third sentence in 7I, states, the transferee shall be subject to the same statute of limitations with respect to the credit as the transferor of the credit. And the transferor is always going to be the donor because the credit can only be transferred once.
That was added in 2007, right? The amendment?
That's correct, Justice Samore. So the 2007 amendment, all the courts that have looked at this issue have said that the 2007 amendment was a clarification in the law, not a change in the law. So the law pre-2007 was the same as post-2007. The General Assembly just meant to clear up what perhaps was unclear language in the pre-2007 language.
And that's what I want to ask you about. Is the fact that there was an amendment to clarify the statute, does that mean that the statute was unambiguous then?
Certainly ambiguity is one of the prongs that the courts look at in determining whether or not it was a change or a clarification. I don't think it's a dispositive prong. There's a couple other factors that the courts look to. I think the General Assembly recognized that perhaps they could have used better language or been more clear, but I don't necessarily think that that renders the statute ambiguous. I think the statute was still fairly clear on its face, just based on the first and second sentence in the statute, that it's the TMR, the donor, that gets to represent and bind the transferees as to all issues, including the statute of limitations. And in our view, that can only mean that there's one statute of limitations, and it's the donors. And so the entire team of transferees has the same limitations period, the same commencement date, and the same expiration date.
So is it your view that we don't even need to get to the amendment, that just the statute, the way it existed before 2007, is clear on its face, that the plain meaning of that language is good enough?
We'd agree with that, Your Honor. I think the 2007 language helps. I think it clears up any doubt that might have existed, but I agree with you. I think just the second sentence by itself does the job as well.
And have you found any case law that says that the legislature can clarify a statute for a purpose other than to clear up an ambiguity? Because I looked it up, and the only cases I can find and there are two lines. One is that when the legislature amends a statute, they do so to change it. And the other line says they do so to clarify an ambiguity.
Right. That's exactly right. And the district court goes through some of this analysis as well. I think the Powell decision from this court, the Ficarra decision, that's a 1993 decision of this court, that those two decisions discuss clarifications versus changes. And I agree with you that the presumption is a change, but that presumption can be rebutted by going through the different factors that the courts look at, ambiguity being one of them. The other two factors that the courts look at are, what was the legislative history on this? Did the legislature state that it was a clarification versus a change? And here the legislature did state that. If you look at the bill summary from the 2007 amendment, it states that our intent is to clarify what we mean by represent and bind as to the statute of limitations. So I think that by itself removes any doubt as to whether or not this was a change or clarification. And the other thing I'd point out about this issue is that there's been 3 different courts that have looked at this issue: the district court in this case, the Court of Appeals in this case, and also the Marcus panel from the Court of Appeals. All 3 of those courts have concluded that the 2007 amendment was a clarification. Let me speak just briefly about the legislature's intent. What problem was the legislature trying to resolve when it enacted this represent and bind framework? The General Assembly's intent when enacting this language was to create efficiencies and economies of scale in the administration of the conservation easement program, similar to those that exist at the federal level, where a tax matters partner is able to represent and bind other partners as to tax decisions. Under this framework, the department is able to administer the program by communicating with just one taxpayer, the donor, rather than the several transferees that might use pieces of the credit that are derived from the single credit. And just as background on this issue, back in 2005 when this was going on, it was not at all unusual for a single conservation easement credit to have upwards of 20 transferees or even more. I'm aware of at least one case where a single credit had 66 individual transferees. And it's just not practical or efficient for each of those 66 taxpayers to hire their own lawyers, submit their own documents, and make their own legal arguments to the department as to why their piece of the credit is or is not valid or is of a certain value. That's the TMR's job. That's the donor's job. And so that's what the General Assembly was getting at. It sought to streamline this entire process by tapping one person, the donor, to represent the entire team of transferees. And that makes sense because it's the donor who owns the land. They make the decision to hire an appraiser to get a qualified appraisal and to take all the steps that are necessary to encumber the land with a conservation easement.
Let me ask you, Mr. Sullivan, why would it be such a great burden if, some taxpayer got on the horse quicker and said, here is all the documentation you need? What's the burden on that? I mean, I understand the argument you made, but it's, the Department of Revenue and the IRS look at everybody's taxes all the time. And so if one transferee happened to kind of get on the stick quicker and say, here's all my paperwork, here's all the paperwork you need, what's the burden there?
Well, I don't know that it's a burden question. It's what does the statute say? And here it says that the statute says the donor gets to make the decision on when they file, what documents they submit. It's entirely possible that different taxpayers could hire different appraisers to reach different conclusions of value. And it's the donor's decision to hire whatever qualified appraiser they want and to reach the value that they conclude is correct. An analogy that I think kind of illustrates this point, it's somewhat of an imperfect analogy, but it's one that this court's familiar with. A clerkship application. A clerkship application has many parts. It has a cover letter, a resume, law school transcript, and letters of recommendation. Now, sometimes letters of recommendation are sent directly by the recommender, and sometimes they arrive in chambers even before the clerkship applicant has applied for the position. Well, the judge or justice is still going to want to receive the cover letter and resume from the applicant to make sure that they actually intend to apply, that their plans haven't changed. Perhaps they've accepted a position somewhere else with a different judge or with a different employer. You're going to want to see that clerkship application and not just the letter of recommendation. And similarly here, the department wants to see that the donor actually went through and took out all the steps that are necessary to fully encumber their land with a conservation easement. For example, in this case, the Medveds actually filed their return before the conservation easement deed was ever recorded. So when the Medveds sought their credit, there was no valid conservation easement. There was no valid credit.
And I was going to ask you about that as a practical matter. What is the timing of the transferee seeking the credit typically? Is it after the transferor has in fact likewise filed that paperwork, or does the sequence often change? I guess I'm just curious as a practical matter.
Sure. So the typical case is in the tax year at issue, the donor is going to take all the steps necessary to complete the CE transaction. That includes getting the appraisal, recording the conservation easement deed, all the steps that are necessary to fully encumber the land. Only after that point do they tend to then sell the credit. And then the transfer actually happens at a later point. There's typically a transfer agreement between the donor and the transferee. They agree on whatever terms they've arrived at regarding the purchase price. And then only after that agreement is executed do both of them then go and file their documents with the Department of Revenue.
And do those tax filings typically occur at the same time, or at least in the same tax year?
Absolutely, definitely in the same tax year. In fact, as we read the statute, the donor and the transferees have to file documents claiming the credit in the tax year that the donation occurred.
So what if, though, the transferor ends up filing late for that same tax year, but gets an extension or something and ends up filing after the transferee?
As happened in this case.
As happened in this case.
In that case, our position is that the statute of limitations does not commence until the donor files their documents, including the qualified appraisal summary, all the things that go into substantiating the credit.
So how does the Department of Revenue then treat the transferee's request for that tax credit?
I think I understand what you're asking, Justice Marquez. So similar to the clerkship application, if a recommender's letter arrives before the clerk takes action to apply, chamber staff will typically hold that letter and then match it with the clerkship applicant once the clerkship applicant is submitted. Similarly, the department will hold the transferee returns and then match it with the donor's return once it comes in.
So the credit isn't actually applied until it's all cleared up, the paperwork from the transferor is actually received and verified?
That's correct.
Okay.
And is that what happened here? There was a hold on the Medved's claimed credit until the Whites Corporation?
That's correct. As soon as Whites Corporation filed its documents, then the department machinery kind of kicked in, and that started the review process.
I think one of the concerns the Court of Appeals had was, are we going to extend this indefinitely, this period of time? As I understand it, there's a limit within which the transferor has to file with the Department of Revenue. Is that correct?
That's correct, Your Honor. I think one issue where the Court of Appeals might have had some confusion is there's a 20-year carry forward for the credit. So if a donor or a transferee, whoever holds the credit, is not able to use the entire credit in the first year or two, they can carry it forward up to 20 years. Now that is different. That is a completely separate feature of the credit from the requirement that the donor actually claim the credit, which means file a return showing that I'm eligible for the credit in the tax year of the donation. They have to do it in the tax year of the donation. Now there's a separate statute, I think you're referring to Section 108, where taxpayers can amend returns. They can do that, they get new information that suggests, I didn't quite have it right with my original tax return, I better amend. If you're going to claim a credit on an amended return, you have 4 years from the original due date of the return. That's a hard stop. After that 4 years, you cannot go back and claim a credit that should have been claimed years earlier. So that's actually a statute of limitations that applies to the taxpayer rather than the department. And so this notion that the Court of Appeals had that, perhaps a donor could wait 20 years to first claim their credit, that's just incorrect. And that's some confusion between the carry forward provision and the requirement that the donor claim the tax credit in the year of the donation.
So there is some level of uncertainty about the validity of the conservation easement, the transfer, but it would be capped at 4 years. That uncertainty would be limited to that 4-year.
That's correct,
Okay.
Justice Marquez. And on the uncertainty point, I certainly understand the concern that the Court of Appeals had. I think they quite rightly wanted to the extent possible, interpret the statute in a way that would reduce this level of uncertainty. And the General Assembly has recognized that in the interim, and they've made some amendments to the statute that reduces some of that uncertainty. There's now, beginning in 2014, there's now a pre-certification process that the General Assembly has created. In addition, I think that there's certain actions that transferees and donors can take to themselves reduce the uncertainty. I mentioned earlier that there's typically a transfer agreement between the transferee and the donor, and those agreements typically have, not in this case, but they typically do have an indemnity provision that says that if the credit is invalidated for any reason, the donor will indemnify the transferees. Now, those transfer agreements could also have other provisions that reduce uncertainty, such as requiring the donor to take all steps necessary to comply with the statute, including by, for instance, filing their tax return by the due date, which didn't happen in this case. Had that provision been in the contract, there would have been other mechanisms to ensure that the donor does everything that's required by the statute. Let me address briefly the Medved's interpretation. Both the Court of Appeals and the Medveds advance this interpretation where a transferee rather than a donor can be the one to actually trigger the statute of limitations. And there's a few reasons why we think that is not an accurate reflection of the General Assembly's intent. The first is that that interpretation nullifies several subsections of the statute, renders them superfluous. The represent and bind language in 7I, I think, is a good example of that. If a transferee can be the one to trigger the statute of limitations rather than the donor, then there's going to be nothing left for the donor to do, nothing left for the donor to represent and bind with respect to the statute of limitations. Another provision that's rendered a nullity under the Court of Appeals interpretation, it's what we call the matching provision. That provision is in subsection 7D, and it states that a transferee cannot even claim or use a credit unless the donor's written matching statement verifies the amount of the credit transferred. Now, I want to stop here and pause for just a moment because I don't think I can overstate the importance of this part of the statute in 7D. This part of the statute is what allows the department to do its job to track credit over sale, to track credit over use, and to make sure that the credit is not being used above the statutory limits. Without that, as in this case, a credit could be oversold, overused. In this case, it was oversold and overused by more than $1 million. And it was not until the donors filed their corroborating statements, their matching statements, that the department was able to detect that fraud and take action to stop that fraud. So another concern that the department has with the Court of Appeals interpretation is that it does lead to certain unintended absurd results. And one of those absurd results was discussed at some length in the district court's decision on page 4. The problem is this: if a transferee's filing can trigger the statute of limitations, a fraudulent donor, like the one in this case, may have an incentive to lie in wait. They may have an incentive to refrain from filing their documents right away and wait until the transferee's statute of limitations expires or is about to expire before finally filing their return and their supporting documents. If that occurred, the donor could then file their documents, the transferee statute of limitations would expire, and then the department would be without any authority to take any action to adjust the transferee's returns. If that had happened in this case, the department, there would have been several millions of dollars of credits that would have been, fraudulent credits that would have been out of the department's reach that it could not take corrective action on. Let me touch briefly on, in our briefing, we call it a due process problem that the Court of Appeals interpretation creates. For this argument, I want to point the court to a Court of Appeals decision. It's the Kowalczyk decision from 2012, and although it's certainly not binding on this court, I think it provides a nice in-depth discussion of some of the rights and responsibilities between the transferees and the TMR. In that case, the court stated that a transferee's election to purchase a conservation easement credit and then claim it as a deduction is similar to a party's decision to enter into a contract in which the party agrees that in litigation arising from the contract, another party will represent its interests. Now, I raise this issue because that same type of contractual or statutory relationship just does not exist between the first filing transferee and the other team of transferees. Now, when the Medveds filed their return in this case, they were not the TMR. They were just another transferee, and they had no statutory or contractual responsibility or authority to represent the other transferees. And if they had tried to do so, the other transferees would have a very good argument that they're not bound by whatever resolution the Medveds reached with the department. That would require more litigation, more redundant hearings before the Department of Revenue's hearing officers, all to litigate issues that had already been hashed out. And that just wasn't the General Assembly's intent when it enacted this representative framework, including the represent and bind language. Let me touch briefly on the second cert issue, agency deference. The department's view is that the Court of Appeals erred when it declined to extend any level of deference to the department's interpretation. Each of the factors that this court historically looks to when it's evaluating whether or not agency deference is appropriate are met in this case. There's codification and rule. We've had subsequent legislative action that at least implicitly upholds the department's regulation. There's uniformity in the department's interpretation. It deals with a complex subject matter. This tax statute spans some 17 subsections and 8 pages in the statute books. It incorporates by reference several provisions of the federal tax code. It's a complicated statute. If there were ever a case, in our view, that agency deference were appropriate, we believe it's this case.
Do we only get there if we find ambiguity, or do we look at do we have to defer the agency either way?
That is a very good question, Justice Gabriel.
I try.
Certainly, I know this question came up yesterday. I don't think this court has adopted the two-step Chevron process. I actually looked at that after yesterday's argument, and I did not see any decision from this court explicitly adopting the two-step Chevron process. But certainly, this court's cases indicate that it is more willing to defer if the statute is ambiguous.
Are you correcting Mr. Yarger's response to my question from yesterday?
No,
Okay.
Mr. Yarger was absolutely correct in his response.
Because that actually contradicts your response. He said that he suggested that we had.
Perhaps I misheard Mr. Yarger. I thought that there was no case explicitly adopting Chevron from this court. Certainly, I believe this court has cited Chevron favorably for general agency deference principles. But I've never seen this court take kind of the two-step process, go through that same two-step process that Chevron does. But certainly, I think this court has cited Chevron favorably just for general deference principles. Justice Gabriel, on your question, whether or not this court has to find the statute ambiguous to extend some level of deference, I don't know that it needs to say that the statute's ambiguous to say, we give respectful consideration to the agency's interpretation. Cases like Gardner from this court cited in our briefing, they mention that we give respectful consideration to the agency's interpretation in all cases, not just cases where the statute's ambiguous. So I think the underlying principle is that we're going to look at the agency's interpretation and give it due weight in the right case. If the statute's ambiguous, perhaps we'll give it even more weight. And once you look at all the other factors that are highlighted in our briefing, certainly I think that agency deference does play a part in the analysis.
Well, if it's unambiguous, what's it matter?
That's correct, Your Honor. If it's unambiguous, if the statute's clear, then you can certainly just apply the statute as written. If there are no other questions, I'd like to reserve my time.
Good morning. My name is Marcia Piccone, and I, along with Chris Dawes, represent the respondents in this case, John and Deborah Medved. May it please the court. The Court of Appeals was correct in holding that under 3922, 522, 7I, the first claim for a conservation easement tax credit, whether it's filed by the donor or by the transferee, triggers the running of the statute of limitations. The plain language, the plain language of the statute supports the Court of Appeals holding. The statute says that a donor and a transferee are subject to the same statute of limitations. The 2005 statute, as this court has noted, does not have the last sentence upon which the department relies. So we would take the position, as we have previously, that was a change to the statute rather than a clarification. But with or without that last sentence, the statute does not indicate whose actions trigger the accrual of the statute, or trigger the statute of limitations. All that says, if you even look at the last sentence, is the transferee shall be subject to the same statute of limitations with respect to the credit. The important point here is looking at the tax credit. The statute merely says that a tax matters representative can represent and bind the transferee with regard to all issues, again, affecting the credit, including the statute of limitations. It does not say that the limitations period belongs to the donor or to the donor, or that the donor's filing triggers the statute of limitations.
Well, what does the language then binding with, I'm paraphrasing, binding the transferees with respect to the statute of limitations means? So in this case, we have a situation where the Medveds filed early, so they would have a 4-year statute running from their filing. The donor files on a different date. We got to pick one, and I guess doesn't bind the TMR's filing binds the transferees mean we have to look at the TMR's, the statute that applies to the TMR?
The statute, again, is silent with respect to whose actions trigger the statute of limitations.
And that's what I'm questioning, because I'm just pushing on you, of course, but I'm not quite sure why you say that. I mean, even if you take the last sentence out, binding the TMR binds the transferees with respect to the statute. Doesn't that mean whatever statute applies to the TMR applies to the transferees?
Well, the same statute applies, the 4-year statute of limitations. The statute is silent with respect to when that is triggered. And if you accept the department's interpretation, basically the department could just take a tax return, see that a tax credit is claimed, and not take any action until the donor files its tax return. The statute requires the donor to file a return in the year that the transfer is made, but it does not require the donor to claim the transfer in that year. In this instance, the Medveds filed their tax return and the department at this point had all of the information that it needed to start to initiate a review. And if you look at this situation where the donor didn't file until a year later, there were still 3 years remaining on the Medved's 4-year statute of limitations. And so in this instance, the bind language really is to the length of the statute, not necessarily when it is triggered. And the I think that the department argued that there's nothing left for the tax matter, or the TMR to do if the transferee's filing of its claim triggers the statute of limitations. That's just not accurate. The transferee will then, the tax matters representative will then continue to handle and all of those issues with regard to that. But the department is on notice at the time that the first claim is made that there is a conservation easement tax credit being claimed. It has the information, and it can initiate a review at that time. And I'm thinking I've not answered your question, Justice Gabriel.
I'm struggling with the language, and so maybe I'll just turn to the last sentence. When it says the transferee is subject to the same statute as the transferor, I don't see, well, it'll help me understand how we don't have to look at the transferor in that situation, just taking that language. I mean, under your argument, I guess maybe what you're saying is it is the same in this case. It's just the transferee goes first, and so it's the same.
The statute of limitations is the 4-year statute of limitations. So it is the same statute of limitations. What it does not address in the statute is whose filing triggers that statute of limitations. The statute is silent as to that particular issue.
But isn't it more than the statute? It's not just that the statute of limitations is a 4-year statute. This is a question, not a statement. That the statute is, 4 years from this date. The statute runs on this date. I think the presumption is that it's a 4-year statute. It's the same 4-year statute. But don't we have to look at when it starts to run?
Exactly. And the statute, you have to look at the language of the statute that talks about all issues affecting the credit. And the credit is filed at the time, in this case, and perhaps in other instances, the credit is you have to look at the credit, and in this case, the credit was filed and claimed when the Medveds filed their tax return. And so the only way to look at that language and to make the determination, because if you accept the department's interpretation, the donor could wait an awfully long time, and even if it's 4 years as they contend, which I'm not sure that we agree with, but even if it is the 4 years as they contend, what you are doing is subjecting a taxpayer, a transferee, to an uncertain time limitation on the statute of limitations. It could be longer, much longer than the legislature intended for a 4-year statute of limitations.
Well, let me ask you one more question if I can. Mr. Sullivan pointed out some language that says we have to wait for the matching provision, we have to wait for the donor to file. There is language throughout the statute that talks about looking at what the donor does. 1261-1106 dealt with, when the donor files paperwork, if there are questions, the department looks to the donor. Doesn't the whole statutory scheme settle on the fact that we look to the donor, that's what creates the credit, and so we're going to go off what the donor does?
The statutory scheme talks in terms of the donor, and it also talks in terms of the transferee. There is a provision in the statute that enables the department to request additional information from both the transferee and the donor if it has any questions. And with regard to what is, they have to receive certain things from the donor, the statute requires that the donor file a tax return in the year that the conservation easement is created. So the department has access to or can request the information that they need to determine whether someone claiming a conservation easement, a transferee claiming a credit, whether that conservation easement is valid, and with regard to the value of that. So the statute doesn't, with due respect, Your Honor, the statute does not just encompass what the donor is doing. It is also looking to the transferee.
Can I ask you a question about that, really specific about the language of the statute? You referred to the part that talks about all issues affecting the credit, and you would separate off what we would normally call the accrual date from the length of the limitations period. But I'm having trouble understanding why that would be in the language. It's pretty clear that the statute of limitations they refer to is one of the things that's included within the issues, all issues affecting the credit. What is there in your separation of the accrual date from the limitations period itself, the length of time that could be understood from the statute of limitations being included within all issues affecting the credit?
If I understand your question, Your Honor,
And that may be difficult to do, given the way that.
well, I didn't mean it that way. But you have to look at just at the language and what's the real issue here in terms of what the department is looking at. The department is looking at whether the conservation tax easement is valid and what is that value. And so it is the credit that is the important aspect. When does the department have notice of the credit? The bind language is not superfluous, I think is what the department argued. If you accept that interpretation, the TMR still is able to deal with all of the issues with regard to the statute of limitations. But when you look at even the statute's purpose in its legislative history, the first claim filed is consistent with the purpose in the legislative history, because this statute is intended to create certainty and efficiencies. The tax matter, I'm just going to refer to it as the TMR, is who handles all of the issues with regard to it. But what that doesn't say is at what point is the statute triggered. If you accept that it is the donor's statute of limitations, or it's the donor's filing of the claim that triggers the statute of limitations, that creates tremendous uncertainty for a taxpayer.
And that may be as a policy matter, but get back to the words just a little. So when we talk about statute of limitations in a typical civil context or general statute of limitations, don't we say you can't ever determine when the statute of limitations is without knowing both an accrual date and a length of the limitations period? So when it says that what initials are we using, the TMR, whatever, it controls all issues affecting the credit, and that includes the statute of limitations. How can we know what the statute of limitations is without a triggering date or an accrual date? And therefore, isn't that part of the statute of limitations? And why then would that be separated out from an issue affecting the credit?
The statute says that the TMR represents and binds the transferee to a whole series of types of things, such as all issues affecting the credit, charitable contribution deduction, the appraisal notifications and correspondence, audit examinations, assessment refunds, settlement agreements, and the statute of limitations. The bind language is with regard to once that determination is made, the TMR deals with the department as a single entity on behalf of all of the transferees, because it's the credit. Once that credit is determined to be valid or not valid, it affects all of them the same. So that's where the bind language comes in.
But why? And the chief is asking much more eloquently the same thing I was trying to get to. It says bind with respect to the statute of limitations. I'm going to try ask it maybe in a different way. Why doesn't that mean it binds with respect to everything about the statute of limitations, including the accrual date? You're saying it doesn't cover when the statute starts running. There's an argument, I think, to be made that says binds with respect to everything related to statute of limitations, includes the accrual date.
The legislature, if it wanted to, could have stated that it is the donor's statute of limitations and that triggers, the donor's filing of the claim that triggers the statute of limitations. It does not. And I recognize the bind language can be somewhat confusing, but it still just talks about whether it discusses the statute of limitations in the context of a whole series of other things that the TMR represents the transfers on. Because The determination of the value and the validity of the credit depends entirely, for everyone who claims that credit, depends entirely on one determination, whether it's valid and the value.
So doesn't, you talked about uncertainty, and I'm sympathetic to the argument you make. Doesn't it, I suppose, Mr. Sullivan and Mr. Patterson would argue, it's more uncertain when it depends on, there's 100 transferees and anybody could file any time. We have even more uncertainty than if we get to look at one person who is the representative of everybody. Why isn't that correct?
It actually creates certainty. This is in the determination of the value and the validity of the conservation easement is at that time, and it is very different now. The statutory scheme is very different now. At that time, the determination was within the control of the Department of Revenue. And so at the first filing of a claim tax credit, the Department of Revenue is on notice. It's their process. They can determine, they have to look at a taxpayer's returns and determine whether the taxpayer is paying the appropriate amount of tax. So at that point, that they are on notice that there is a conservation easement tax credit. If the donor follows the procedure in the statute, they would have filed a return at the same time. But at that point, they're on notice. They can request information that they don't believe they have. They can request it from the transferee or the transferor, and they have 4 years to do that. And once that determination is made, then that determination affects everyone, all the transferees of that tax credit.
But part of this credit requires an appraisal, right?
Correct.
And so under your scenario, all 100 transferees can file a different appraisal. And then we have a mess, as opposed to looking at one person. Or, relating to the due process concern they raise, I could see one transferee file an appraisal, and transferee number 50 says, that appraisal's wrong, and it's undercutting the credit. I like my appraisal better, as opposed to having a situation where we're going to look at one person who's going to file the appraisal.
Well, the appraisal that was filed in this case was the only appraisal, and they're requesting a qualified appraisal. It is not my understanding under this statute that any transferee can file any appraisal it wishes. But if that was, and I don't believe that that is the statutory scheme that's required here, you still would be dealing with the TMR, and at that point, what we're just saying is at the time of the filing, the department controls the process. They have 4 years within which to make a determination whether that tax credit is valid and whether the taxpayer has calculated the amount of tax correctly. So because it runs with the credit, it's going to be binding on everybody regardless of when the department starts to look at it. So we believe that the legislative history also supports the 4-year statute. Having the first claim filed, or having the first time that a transferee or a donor files the claim is consistent with that because it intends certainty and efficiency. And one of the statute's purposes is to incentivize conservation easements for the public welfare and to provide pecuniary relief for, I think the term is land rich, cash poor. And so to allow the department's interpretation that you have to wait till the donor does not provide the certainty and is certainly a disincentive.
Can I jump in and just follow up on your argument a few seconds ago? To make sure I follow it, your point is even if the transferee files first, at that point, Department of Revenue is on notice, and even if the transferee doesn't provide the complete package of information, the department can go collect that from the transferor and has 4 years to do that. Does that accurately summarize your position?
You can collect it from the transferor or the transferee.
Or the transferee.
Yes.
Is there, though, a distinction between merely collecting that information and the 4 years that the department would have to verify that information to determine its validity? In other words, at the end of that 4-year collection period, they might be able to receive it, but they'd be out of time to do anything about it in case there were concerns about its validity?
The department has 4 years within which to gather whatever information it needs and to make a determination with regard to the validity and the value of the conservation easement.
But I guess, and the reason I bring that up is if instead the accrual date was the date at which the transferor files, and presumably the transferor does have an obligation to provide all of that information, that clock to verify that information would commence at that juncture. And the department would then have 4 years to verify that information, as opposed to simply receive it and collect it. Perhaps my question makes no sense, but I'm just trying to understand if there's a difference between the department's time period to verify information that it has already received versus 4 years to simply collect that information on the front end.
No, I don't believe there is a difference. I think the 4 years, if you were to accept the department's interpretation and the statute started to run at the time that the donor claimed the statute, or excuse me, claimed the credit, there would still be 4 years within which to gather, collect, and determine the validity and the value of the conservation easement. So they would, if the transferee is the first to file, as it was in this case, the department had 4 years within which to gather the information, to determine whether they believed that the conservation easement was correct, whether the value was correct, and whether it was valid. And what happened here under the current statutory scheme is very different, because under the current scheme, the determination of the value and the validity of the conservation easement is determined up front. And before anyone can file, the donor has to receive a tax credit certificate. So all of the determination on value and validity is done up front at this point. In 2005, it was the statutory scheme that we're looking at now, where if the department did not have information, there was certain information that was to be required to be filed with the tax returns of both the transferee and the transferor, which was very similar at that time. May not have been absolutely exact, but in this instance, the Medveds filed all of the information, or at least most of the information that the department, the donor would have filed as well.
So may I ask a factual question? I may have misunderstood how the appraisals work here. So if I understood what you just said, the appraisal gets filed when the tax credit certificate gets issued, so we all know what the appraisal is, and then the credit gets taken later?
That is under the current...
Forgive my ignorance if I missed it.
That is under the current scheme.
Okay.
The statutory scheme has been amended and changed throughout from 2005 to today. Under the current scheme, all of this determination as to the value and the validity is done up front before anyone can claim a conservation easement, before the donor or transferee can claim.
Ms. Piccone, I want to go back to the language of the statute. So as I read subsection 7I, it says the TMR binds the transferee with respect to all issues affecting the credit. And then it says that includes, for example, the appraisal, right? So if the TMR, whatever the TMR did with respect to an appraisal, you'd agree that that would then bind the transferee. Is that pursuant to what the statute says, right?
That is my understanding, Your Honor, and that the information with regard to the appraisal and all of that is given to the department. In this instance, it was given to the department both by the Mr. and Mrs. Medved and the donor subsequently.
Okay, it also includes audit examinations, and so it would be the same thing. Whatever the TMR does with respect to audit examinations binds the transferees. And then it also includes, of course, the statute of limitations. And so I'm trying to figure out why is it then that whatever the TMR does with respect to the statute of limitations, including triggering it, why doesn't that bind the transferee under the plain meaning of the statute?
The statute does not discuss the triggering of the statute of limitations. The statute talks about binding with regard to a number of factors. And it does not assign the statute of limitation to the donor or to the transferee. And so I think the difference is the statute of limitations is a 4-year statute of limitations. And so that is what the statute refers to. And if you look at the language that was added subsequent to 2005, that's also what that says, is that the same statute of limitations, which is a 4-year statute. So that is what the language is referring to with regard to the statute of limitations.
So I still am not understanding what is so there's represent, the word represent, and then there's the word bind. In what way is the TMR binding the recipients, the transferees, to the statute of limitations if the statute of limitations can start to run from one of the transferees and not from the TMR? That's an active verb, so
The bind language references the statute of limitations, which is the 4-year statute of limitations.
But actually, the statute of limitations binds everybody, not an action. I mean, there's a 4-year statute of limitations for everyone. That's what the law says. That's what binds them to 4 years. But the language of the statute seems to suggest something that the TMR does that binds the transferees. What is the TMR's binding as to the statute of limitation?
With respect to the credit, the TMR is binding with respect to all matters with respect to the credit. And you have to look at the credit. And once the credit is claimed, then the statute of limitations begins to run and the TMR is binding with regard to that.
But in that version of events, it's the filing of the claimed credit that binds everyone with regard to the statute of limitations, not the TMR that binds everyone.
It is the filing of the claimed credit. And if you'll excuse me for a moment. Justice Hart, did I answer your question?
I think you did. You said it's the filing of the credit that binds, but I don't think that's what the statute says.
Well, the statute is silent on whose filing triggers.
But what
this.
can the statute mean when it says the TMR will bind as to the statute of limitations? On your interpretation, what can that mean?
It means that the TMR binds with regard to the 4-year statute of limitations. And to the extent that there are different interpretations with regard to this statute, the ambiguous tax statutes, to the extent there are reasonable interpretations, are to be construed in favor of the taxpayer. And they're not binding particularly where the undisputed facts and there's issues of law. In this instance, you have to look at the language of the statute, and the plain reading really does support that because it doesn't say the limitations period belongs to the donor. And the bind language is understandably a little confusing with regard to the statute of limitations, but it clearly is talking about the 4-year statute of limitations. You have to look at both 107 and 522 because in this instance, if you don't read it that way, then the transferee is subject to a very uncertain and unpredictable determination of whether or not their easement's going to be disallowed.
So one place that certainty and predictability could come from, and it sounds like it sometimes does, although not in this instance, and I'm sympathetic to the Medveds having gotten, I guess, sort of swindled here, but one place where certainty could come from is from the private agreement between the donor, the TMR, and the transferee, right? That sounds like they could have had an indemnification clause. There could have been a provision in the agreement that said the Whites Corporation will file their taxes with this claim in this year, the same year the Medveds is. That could have been, certainty could have been created in that way.
Well, the statute requires that the donor report in the tax year in which the conservation easement is created, the conservation easement. And the statute requires that as well. Whether or not there could be certainty, whether a transferor or a transferee could contract for other provisions, I don't think the statute prohibits that.
Okay.
I'd like to touch briefly on the issue of deference. And the Court of Appeals in this case correctly noted that to give deference, but correctly concluded that the statute was inconsistent. The agency's interpretation and the agency's regulation is inconsistent. The agency view is advisory, not binding, and the statute in this case, and we have talked about it, doesn't assign ownership to the donor, TMR, or transferee. It ties the statute of limitations to the credit, not to a person. The regulation, it results in the agency rewriting the law. The specifics of the statute of limitation of the transfer or any extension of the statute of limitations, that is not in the language in the statute. It contemplates an extension of the statute of limitations. There is nothing in the language of the statute that talks about that. And it subjects as we have discussed, it subjects the transferee to an extended statute of limitations. It's counter to the legislative intent of a 4-year statute and the certainty to be provided to a taxpayer. You can't view this statute expansively, which is the way that the Department of Regulation or the Department of Revenue is doing. You have to look to the language of the statute, and the statute does not assign the triggering of the statute of limitations to the donor, to the transferee, or to some other entity.
Can I ask one more question? I just want to be sure. Is there some other statute of limitations other than 4 years that could be applied? And if the TMR's 4-year statute of limitations didn't bind? I mean, when you say that's the issue of the statute of limitations that's binding, are there other available statutes of limitations?
The statute of limitations is 107, and it is the 4-year statute of limitations. I'm not aware of another statute of limitations that would be applicable in this case.
Okay.
And we just request that the court affirm the Court of Appeals opinion.
Mr. Grant? I mean, Mr. Sullivan?
Mr. Grant.
Thank you, Mr. Chief Justice.
Try not to get too familiar here.
Just a few points to hit on in rebuttal. Justice Hart, on your question, is there another statute of limitations that could apply? The answer is no. There's one statute of limitations. It's in 107, and it's a 4-year statute of limitations. Counsel several times said that, it's the same statute of limitations, and I think what she meant is it's the same length rather than 4 years, rather than the same commencement date and the same expiration date. I think that cannot be correct because even putting aside Section 522, it's the same statute of limitations for all income taxpayers in Colorado, and that's 4 years. So if that's the case, there would have been no need to enact Section 522(7)(I) and to have the language regarding the statute of limitations. So
Is partly that, maybe this is oversimplified, but is this coming down to an argument about whether statute of limitations means only the limitations period, or it includes both the triggering or accrual date and the limitations period?
I think that's a very good way to think about it, Chief Justice Coates. I think, in our view, it's the whole package. It's both the length and the actual dates, the commencement date and the expiration date. It can't be just the length because, again, the length is the same regardless, even if you cast aside 522(7)(I). Counsel said that the statute does not allow any transferee to file an appraisal. That's the TMR's job. And on that, she's correct. The donor and the donor alone, as the TMR, is responsible for obtaining a qualified appraisal. That's their job as the TMR. And this goes to the issue that was discussed, whether or not the department can request additional information from the transferees. In the normal case, 99.9% of the cases, the transferee is not going to have the qualified appraisal because they didn't get one. Their donor didn't give it to them. That's not their job to get the qualified appraisal. That's the donor's job. And it's the donor's job to submit the qualified appraisal summary to the Department of Revenue. So this notion that the department could go to the Medveds and get additional information doesn't quite line up with how this actually works in practice. Again, under the statute and in practice, it's the donor and the donor alone that's going to obtain the qualified appraisal, which is several thousands of dollars in most cases. So the transferee, understandably, is not going to incur that expense.
So there's just one qualified appraisal. I misunderstood. Each transferee couldn't go get their own appraisal. There's just one when the credit is first, the certificate is issued?
Under the new framework, that's correct.
All right, was it different under the old framework?
Under the old framework, in a normal case, there's going to be one qualified appraisal. That's correct. Now, if there's a big dispute later on in litigation or in the administrative review process, the department or the taxpayer, be it the donor or a transferee, they might insist on an alternative appraisal. Let's get a second opinion. But again, that's the rare case. And typically, it's going to be just the donor that incurs the expense to get a qualified appraisal from a qualified appraiser.
So help me then, I know your time is limited. So you said we really need to wait for the donor to file because that's when the department has all the documents it needs. What documents does the donor file at that time that it didn't have before when the certificate was issued?
Yes, Your Honor. So there are two main forms that the donor files, and this I'm referring to tax year 2005. There's a qualified appraisal summary. That's called a Form 8283, and there's several things on that form. It's a quite lengthy form that are required by the donor. It includes things like a signed acknowledgement from the donee organization, the entity that actually receives the donation. And that acknowledgement says that basically this is without consideration. This is a true donation. We're not giving you anything in exchange for this donation. It has to have a signed declaration from the qualified appraiser, and that declaration has several subparts. It has to include that the appraiser holds themselves out as an appraiser, that there's no relationship to either of the parties, the donor or the donee. The appraiser's fee can't be based on a percentage of a value. It can't be a contingent-based fee. The appraiser hasn't been barred from presenting evidence to the IRS, hasn't been disciplined by any disciplinary body. It has to include the fair market value on the donation date, a property description including the physical condition of the property, has to have the manner of acquisition of the property, the donor's adjusted cost basis in the property. I mean, the list goes on and on and on, and these are items of information that only the donor is going to have. The transferee is not going to know, how did the donor acquire this property? Did they acquire it by gift? Did they purchase it? How much did they purchase it for? Was it a discounted price? All of these things go into the department's review because if the holding period, for instance, is less than 1 year, that's going to affect the tax benefit that the donor is entitled to receive because it's considered a shortened holding period. Again, so that's why the department needs this information from the donor. Just like this court, when they're looking at clerkship applications, they insist on having the actual application from the clerk and not just the good word of the former employer sending the letter of recommendation. It's the same sort of idea. And then finally, I just mentioned on...
Unless we got more questions,
sorry.
I think you've
We'd ask that you
run out. Okay, thank you.
Thank you.
I appreciate the arguments of both counsel. Case will stand submitted, and the court will be in recess until 1:30.